Добрий ранок.
Good morning.
Good morning, everyone. So today we are going to conduct the interview for the position of the candidates for the position of the disciplinary inspector. And at the beginning, I would like to start introducing our commission. Today we have 5 commission members. I'm Reda Moliene, the chair of the commission, and there are commission members present: Olena Kovby, Olha Popikova, Pavel Zelinchik, and John Ehrlich. Do you have any requests regarding the composition of the present commission?
Відсутні.
None.
Thank you. So our interview will last for about 1 hour, and we will give you a floor to present your motivation, your qualifications that allow you to come and to apply for this position. Then we will ask questions about your professional experiences, about maybe some integrity and ethics standards, and at the end you will have several minutes for your final remarks or comments. And also I would like to inform you that our interview is broadcasted and is public, so if there is any information during the interview which falls under restrictions for its disclosure according to martial law, please inform the Commission and we will make our decision accordingly. So if there are no questions at this stage?
Відсутні.
None.
Thank you. So we could just start our interview from your presentation of your motivation. Why are you applying for this position, and what is your vision about this service and the role of the service in the judiciary? Thank you.
Yes, thank you. And good morning, everyone, again. I'm happy to be here, and thank you for the opportunity to be in front of the Commission and the society and to explain my motivation and competence regarding this position. Sorry, can you please speak a bit slower so that interpreters would interpret everyone? Yes, of course. I really believe that the judiciary plays an important role in the society, and it is necessary to have trust in the judiciary, which is impossible to achieve without disciplinary liability. Disciplinary liability is something that is ensuring trust of the society. The disciplinary body that is considering disciplinary complaints has to be for sure independent and impartial. And disciplinary complaints that are considered have to be considered in a timely manner, and a timely decision has to be made. And in order to ensure impartiality of the disciplinary body, the service of disciplinary inspectors has been created, and it has been granted with such authorities as preliminary consideration of the disciplinary case, and accordingly to remove members of the disciplinary body from the preliminary check of the disciplinary case and disciplinary proceeding. The importance of the role of the disciplinary responsibility and the role and functions of the disciplinary inspector are my motivation for this position. I believe that really, in such a way, there will be ensured restoration of trust in the judiciary, its maintenance, and maintenance with the rights of complainants and judges. That is my key motivation, and I do want to hold this position in order to serve the society overall and accordingly to serve the state as well regarding that. With respect to my competence, I have experience of 14 years in the sphere of law. I started my career from the position of the Secretary of the Court Hearing, which I held from 2010 to 2012. From 2012 to 2018 and 2019 to 2024, I was the assistant of the judge in the Administrative Court of Appeal. I was also the the secretary in the Administrative Court. Since 2024, I have been the attorney. I have individual practice, and I also represent the interest in administrative courts, commercial courts, civil, and as the defense attorney in cases on administrative offenses. Such a long experience at the position of the secretary of the court hearing, assistant of the judge, and then attorney has provided me with the possibility to have in-depth knowledge in the sphere of procedural aspects complied with by the court, as well as internal organizational work of the court itself. I have worked during different periods of time of the court's functioning. Sometimes we had huge workloads when one judge had about 2,000-3,000 cases. So I know for sure what workload means, how to manage it. Also, that is administrative court where I worked. It takes part in election-related cases. That's why I took part as the court secretary and as the assistant of the judge in such cases. And we worked, among other things, beyond normal working hours, during nighttime even. So I know for sure what it means to have functioning of the court, it means to work extra hours, and how to organize work when I have huge workload. Besides, since I've been the court secretary and the assistant of the judge, and I am the attorney now, I have directly participated in the study of evidence, different evidence. That was about interrogation of witnesses, electronic evidence, and written evidence. So, accordingly, in the Court of Appeal, the Court of Appeal may go beyond arguments and requirements of the appellate complaint and to study some evidence. So I, as the assistant of the judge in the Court of Appeal, I took part in the collection of evidence if it was established that there were some violations committed by the court of the first instance. Of course, since again I was the assistant of the judge in the Court of Appeal, for a long period of time I had an opportunity to study which mistakes were made by the court of the first instance, which may result in disciplinary liability as well. Also, the Court of Appeal where I worked had 3 districts. That is quite an extensive work. We also were responsible for summarizing and generalizing the case law, and I took part in some work regarding that, and I was also summarizing quash decisions of the Court of the First Instance and the Supreme Court. Also, I would like to point out that work in the administrative court, in my opinion, gives me the respective qualification and competence to fill in the position of the disciplinary inspector, because the administrative court is the court where the decisions of the HCJ on the disciplinary cases are being challenged too. And those principles that have to be applied during the consideration of the case have to be also applied while drafting the decision. I mean the decision of the disciplinary chamber. And the disciplinary inspector is responsible for drafting these decisions, and they have to be based on the law. They have to comply with the rights of all participants of the respective disciplinary proceeding, and accordingly, the disciplinary sanction has to be proportionate, and all of that has to be based on admissible evidence as well as proper motivation in the decision. Summarizing, I would like to say that my 14 years of experience in the judiciary at the positions of the court secretary, assistant of the judge, and attorney provides me with opportunity to fulfill duties of the disciplinary inspector at a high level. Thank you.
Thank you very much for a well-prepared presentation of your motivation and your professional competences and experience. And I think we will come back maybe to discuss some aspects of the motivation and your professional turns. But now I would like to give a floor to our commission member, Olga Popikova, to start this questions stage and session, and we will go through all the questions regarding your professionalism. Thank you.
Thank you, Rada. Good morning, Svetlana. That is your second time when you are participating in this competition. During the first competition, you failed the cognitive testing stage. In my opinion, it shows that the pathway that you have selected, that you are really trying to get the position of the disciplinary inspector since you are participating in the competition for the second time, and this competition is not that easy. I have the following question to you. Please tell us, you really have extensive experience of working in courts, 14 years, and the position of the secretary and assistant of the judge, so you are very well aware of the work of the judge, court, and the judiciary in general. My first question is the following. Right now we have ongoing competitions for positions of judges of local courts. Are you taking part in any of those competitions? No, right now I'm not taking part in competitions for the position of the judge. So, you have decided for yourself that you do not want to be a judge. That's your right, that's your choice. But my question is related to the fact that, as a rule, I'm a judge. And I also held positions of the secretary of the court hearing and assistant of the judge. And as a rule, all assistants are dreaming of becoming judges. Why haven't you decided on that? I want to say the following. For me, the priority is this position of the disciplinary inspector because I have selected this pathway even before the start of the competition, and I'm really interested in this position. And I have been interested in long since before the competition was announced, and I have been following that since the discussion of the idea. I applied for the participation of the competition, but due to technical reasons, I was not admitted. But I'm even happy for that because then the competition for the disciplinary inspector was announced again, and that is my priority, and I want to get this position for at least 5 years. That's my key goal now. Yes, I understand that, but the position of the disciplinary inspector is unknown for you. I mean, of course, your career pathway is, as far as I understand, is related to your desire to be involved into processes in the judiciary, but not being a judge, right? You know, the position of the judge is not interesting for you right now. I cannot say for sure that I'm not interested in the position of the judge, but as of now, that's the matter that I've right now, based on my experience, I can be a judge of the first instance court only. And for me, the disciplinary inspector is a broader notion. These are about different jurisdictions. And I believe that since I have this experience of being the secretary, assistant, and the attorney, I can bring more benefit at the position of the disciplinary inspector now. Why is it important for you? Again, I would like to emphasize that I do believe that we have to restore trust in the judiciary, and we have to build our judiciary in such a way that it is sure and that the society is confident that procedures comply with the law and with the rule of law. And complainants have to believe in that as well. In view of my experience of working in the court, I do believe that it's important. Okay, thank you. And in your opinion, how activities of the service of disciplinary inspectors can help to increase the authority of the judiciary? When we are talking about some goals, objectives, as to how important it is for us, sometimes I have a feeling that these are like mottos and slogans, but they have to be filled in with content in order to really understand that. And I would like to repeat my question again. In your opinion, how can the service help to increase the authority of the judiciary? Firstly, as I have mentioned before, we need to have impartial disciplinary body, and impartiality of the disciplinary body is provided by in such a way that it is not taking part in the preliminary check of the complaint. With respect to authorities and duties of the disciplinary inspector, many factors play a role here. I believe that we are talking about the speed of responding to disciplinary complaints. These are respective requirements for collection of evidence that will provide full possibility to the disciplinary chamber to assess those actions that the judge has committed. And also that's about some powers of disciplinary inspectors regarding the return of disciplinary complaints. That's also important. And if this work in totality is performed at a professional level, then accordingly our society will see that guilty judges are being brought to responsibility, and complainants who groundlessly submit such complaints will not have their complaints accepted and will have their complaints returned. Okay, can you please describe in what does it mean to be impartial for you? What does this notion mean? What is impartiality? Impartiality, of course, corresponds to the notion of independence, and impartiality is the attitude towards some situation that is not subjective. So without any influence, taking into account only respective law and requirements regarding compliance of rights of the complainant and the judge during the conduct of the preliminary check of the disciplinary complaint. That's if we're talking about this process. Okay, tell me please, do you have such experience of independent decision making? And maybe we are wrong, but the secretary, the assistant of the judge, do they have such an option as being independent, impartial, and autonomous? No, of course. The secretary of the court hearing and the assistant of the judge do not have their own authorities regarding decision making according to the current legislation. Of course, all the actions that I committed were under the control of the judge, and the responsibility of for decision making is on the judge. And since it was the Administrative Court of Appeal, the decisions were adopted by the panel of judges after deliberations. But for some period of time, I've seen how these decisions were adopted, which mistakes were made by the first instance court. And now I work as an attorney, and in this particular case, I do have some powers and discretion from my client, of course, upon agreement with the client. But I'm building how to prepare for the case. Overall, I represent interests in the court. And that's some preparation of evidence and of legal justification. And of course, I inform my client about that, and we agree on that. But that's my experience obtained at the position of the secretary, and assistant can be now used as the attorney. Tell me, please, have you encountered situations when your position at the position of the judge's assistant did not correspond to the legal position of the judge? And you, of course, do not name surnames or cases, but what did you do in such instance if the draft decision that you prepared and that you considered to be appropriate did not correspond to their vision? Do you have this experience of convincing, discussing? How did you work?
On that matter, again, I would like to take into account that all discussions and convincing process or justification which I could have provided, it was without my powers, and in order not to, go over as this balance and influence on the administration of justice process committed by a judge. And also I had on my own opinion. And further, my opinions were supported by the Supreme Court. So, sorry, were you able to convince the judge that specifically your position was right and whether it was taken into consideration? Yeah, definitely they took into account our discussions, but I can't say for sure that I influenced on the administrative justice process and I convinced judges to make some decisions. Yeah. but discussions were, yeah, definitely. There were discussions, and of course, I can prove my arguments, and it's also confirmed by the fact that now I'm an attorney, and even despite of the fact that I have been working not for so long periods of time, but I have already won quite a few cases, so I can justify my position. I can with relevant reference to provisions of the law. Dear Svetlana, tell us, please, to your opinion, why we have such significant high number of complaints against judges? Regarding the trust issue and the number of complaints, I would say the following, that we can't say that we have no trust at all to the judicial system. It's confirmed by the fact that there is an increased number of complaints submitted to the judicial system, specifically during the martial law. So now we can say that citizens of Ukraine and those who have no citizenship but live in Ukraine, during the martial law, they think that specifically courts shall protect their rights and freedoms. But at the same time, unfortunately, there are some objective and subjective factors which impact on the general process of submission of complaints and trust in general. Of course, a period of consideration of cases is the factor which impacts. Sometimes it's motivated by some objective factors such as the workload of judges, but sometimes it's not motivated by objective circumstances, but rather by some subjective circumstances. So here, I can't say for sure that there is that we have violated deadlines for consideration of cases only because of the high workload. Sometimes complainants don't want at all to understand why their case is not considered at all, why it's not considered to be as non-priority. For a complainant who submits their complaint to a court, they think that their case is a prioritized case, even if the law says an opposite thing. Also, sometimes there is different motivation for there is indicated in complaints, because complainants, what they want to be heard, they want to for their cases to be qualified and to justify that yes, indeed they have this right or that right. That's one thing. Another factor, that's the workload and workload of judges, and sometimes draft decisions are submitted but to the system, but they do not correspond to the factual circumstances of a case. So, such cases exist, and of course they negatively impact on the trust in general. What else impacts on the trust? That's also enforcement of court decisions, and it also includes the period of consideration of cases. According to our legislation and according to the case law, we have quite significant problem with non-enforcement of court decisions. That's what related to the cases themselves. And of course, there are some behaviors of judges which go beyond the court system. They also impact on the submission of complaints, but I can't assess a specific factor. Okay, let's assume. So your opinion is interesting. Thank you for this. And I would like to ask you the following. So if a complaint is submitted to a disciplinary inspector. Let's imagine it's you. You are a disciplinary inspector. And the complaint says that the decisions made by a judge have no relevant, appropriate motivation, or circumstances do not correspond, factual circumstances do not correspond to the ones indicated in the case. So whether indeed a disciplinary inspector can identify the elements of a disciplinary offense, would it be actually an attempt to look at the content of the decision? Regarding the evidences and regarding the disciplinary complaint itself and regarding the evidences, no, we don't look at the evidence, but regarding the motivation of a judge, yes, there are some, some things here which we can look at. So So yes, we shall look at motivation presented by the parties to the case, and we shall dwell upon details of the case. Got you, thank you. There are two other questions from my side, if I may to ask. So, at which stage of a disciplinary complaint verification and consideration of circumstances shall be done? Circumstances to show that yes, indeed, there are signs of a disciplinary offense present in behavior of a judge. I would like to say that it could be done even as a preliminary consideration, because in order to open disciplinary proceeding, you shall have some preconditions, you shall have some actual circumstances, and a complainant shall refer to them. And also, when we carry out this preliminary check or verification, we have right also to ask for some materials or information in order to confirm the facts. But of course, the whole verification is done during the stage of consideration. So both preparation of a case and consideration of a case, yes, on both stages, because decision or a conclusion of a disciplinary inspector could be supported or not supported by HCJ. Thank you. Another and the last question regarding the recusal process for disciplinary inspectors. So the HCJ rules of procedure says the following regarding reasons for recusal of disciplinary inspectors. These are two cases. It's a potential and real conflict of interest, and such situation shall be considered by the head of the HCJ. So if such application is submitted at the stage of preliminary consideration of a case, and if not, if that's not a stage of preliminary consideration of a case, if that's if it's during the consideration of the findings of disciplinary inspector, when findings of a disciplinary inspector is considered or heard at the session of the HCJ. I'm not sure, I could be mistaken, but I think that the disciplinary chamber decides on that matter. Thank you, dear colleagues. That's all from my side. Thank you. Thank you. Hello, dear Tatiana. I would like to go back and to ask follow-up questions for Olga's questions. So you have told us about the necessity to renew trust to the judiciary system. To your opinion, why do you think, what's the reason for the lack of trust to the judiciary system? I think I have already answered this question. I think that here there are so many different factors which actually cause distrust to the judiciary system. So everything that I have told you already before, it's related to the process of consideration of a case. So it means that the person thinks that their case has not been considered inappropriately. Sorry, let's not repeat ourselves, but if decision is made and you will be appointed to the position of a discipline inspector, how you are going to influence on renewal of this trust as a discipline inspector? I think that with my work. So if I do my work in a qualitative manner, including if I manage to ensure impartiality of the service of discipline inspectors, it will help, it will contribute to renew the trust. Unfortunately, for a long period of time, complaints were not considered. People were not heard. Even maybe there were even some cases when judges should have been brought to disciplinary responsibility at that moment. Okay, let's continue. You have done your work very well. Let's imagine. So you have considered a disciplinary complaint very well. To your opinion, your finding is a very qualitative one, and you made a conclusion that indeed there is a reason to open disciplinary proceeding. Your finding is submitted to the disciplinary chamber. There is a session, and the disciplinary chamber listens to your findings, and they think that there are no preconditions to open a disciplinary proceeding. What's your action? What's your next action? action. In such case, I can challenge the decision of the disciplinary chamber and submit this challenge to the HCJ. Of course, I will read a decision of the disciplinary chamber. I will familiarize myself with this document. I will read in detail what is their justification, why they do not support my position. But if I'm sure in my position, if I'm sure in my verification process, and if I think that yes, indeed, there could be a disciplinary offense, and yes, I would challenge. So you're going to challenge the decision of a disciplinary chamber member or decision of a disciplinary chamber. Who is making decision? Decision is made by the disciplinary chamber. So the disciplinary chamber. So I'm going to challenge the decision of disciplinary chamber. Okay, but that's in a situation when there is a proposal of disciplinary chamber member to have another decision. But if there is a decision to return this case back to you to improve the findings, I have no right here to agree or not to agree with such a decision. I have a right to receive back this case, to work further on it, and to submit it one more time to consideration of the disciplinary chamber. Okay, thank you. Tell us, please, why do you want to have this position of the disciplinary inspector? What's your motivation? Again, I will reiterate that I have been working for a long time in the courts. I had seen different narratives existing in the society regarding the judicial sector. And here we can say that if the justice is administered, not always it's so perceived by the public. And I think that if disciplinary responsibility is implemented in a proper manner, it will help to strengthen the judicial power, the judicial branch, and it will help also to complain regarding actions or behaviors of judge if there is any disciplinary offense. Do I understand you right that you are afraid of some negative impact on you as a judge in comparison on you as a disciplinary inspector? No. I think that I would contribute more doing specifically this job because I think that this job is important. I have worked in administrative court. So I know that there are judges in administrative courts. So administrative courts will keep working, but that's why I would like to contribute specifically to the role of a disciplinary inspector, specifically taking into consideration that there are vacant positions there, and it will not be only me working there. There will be other disciplinary inspectors. Okay, tell me please, do you have a specialization as an attorney? What is your specialization? I'm more specialized in administrative cases, but I also work on civil commercial cases and as defense attorney in cases on administrative offenses. Tell me please, does your previous experience as a judge assistant in the administrative court help you to present interest of your clients? For sure, such experience of my work in administrative courts helps me because now we have unified, legislation on different processes. But of course, there are some discrepancies in different branches of this legal field. But I have general understanding. I know how to motivate my position for it to be admitted in the court. Okay, then tell me, when you present interest in the administrative court, what do you think? Are you treated with preferences by judges because you have worked there as a judge assistant? Here, I would like to pay your attention to the following. I had worked as a secretary in the Odessa Administrative Court, and I was assigned to one judge. But since 2024, this judge became retired, and in another position, I worked exclusively with two judges. One of them is retired already, and another judge with whom I had worked doesn't consider cases where I present interest to my clients. So it means that you have never been a legal representative of cases considered by judges with whom you had already worked before. No, of course not. I would say that, as a secretary, in some cases, maybe I worked with some judges in some courts during the period from 2010 to 2012. But you know, it was a long time ago. I don't remember for sure.
So, Pani Svetlana, we were talking a lot about your professional experience and competences. Of course, you have this extensive experience in courts, and you know process, and you know how the justices administrate. I would like to ask you about some personal qualities that are important for a disciplinary inspector. What probably three the most important personal competences you have to possess if you want to be a good disciplinary inspector, in your opinion? What are the most important?
You know, here we can of course mention so many of them, but maybe I think that impartiality, so it's their work. A disciplinary inspector shall be impartial, shall align their acts with rules of law, and commitment to the profession. So regarding myself, I would say that my style of work is the following. I'm capable to analyze legislation, I'm capable to analyze factual circumstances, evidences, and altogether gives me an opportunity to be professional and competent to do this job.
What about some resistance to external or sometimes internal pressure? Because usually in this kind of activities, in this kind of professions, people experience a lot of pressure, different kind of pressure. Do you consider it is an important quality to be able to resist?
Yeah, of course. I said that, yeah, that's impartiality, what I mentioned, and for me, impartiality also includes resistance to pressure, so resistance to any kind of influence, including influence from the side of the society, because of course the High Council of Justice considers certain high-profile cases. There could be some publications in the media, but if the society thinks that a judge should be brought to responsibility in such a case, it doesn't matter that indeed such judge shall be brought to responsibility. So in such a situation, you shall go through all procedural stages only according to the law provisions, and correspondingly, disciplinary responsibility of a judge only comes if he or she commits a disciplinary offense according to the law.
And could you please think and remember maybe some situations in your life when you got some kind of a pressure? It could be not only professional life, it could be your personal life or some relationship with friends or other people, when you experience this kind of internal or external pressure and some kind of situations where you had to do a choice and it was difficult for you?
Well, I will talk about professional activity more. So the real or potential conflict of interest never happened at my work because, again, I'm not granted with decision-making powers, but of course there is influence. Since, as I've mentioned today, I held a position in the administrative court, and that is about consideration of some specific cases related to election process as well. And all the time there is ongoing pressure from the society through some publications, posts, protests. I also believe that work itself is pressure as well, because you need to work at nighttime, you have to come to the court at 3 a.m. And consider the case at 5 a.m. So all of that in totality is really pressure. And I also worked during the period of the coronavirus pandemics. The court did not stop functioning back then, and we also continued working during the martial law. The court did not stop working. So all of that in totality really impacted me, but I've managed to cope with that, and I accordingly performed my duties.
Thank you. And one question, and I will give the floor to my colleagues to be able to ask questions. So you have now more than 1 year of practice as a lawyer, and you had some cases in courts, and you already mentioned about some mistakes that, in your opinion, were made by the courts of first instance, which were observed by you while working in the court. Could you please indicate if you had experienced some kind of, in your opinion, mistakes or misbehavior, procedural misbehavior of judges during this 1 year practice as a lawyer, while you have this procedures in courts?
With respect to the behavior during court hearings, no. Everything was within the framework of the procedural legislation, in my opinion. With respect to judicial mistakes, yes, I submitted appellate complaints, but that was within the framework of resolution that following the appellate procedure. I was entitled to submit the complaint because I believe that my arguments were not accepted and the issue was not resolved on the merits, and the Court of Appeal satisfied that complaint.
From judicial activities, the behavior and procedural behavior of judges, what kind of shortcomings or challenges do you see in courts in general sense during the presentation or submission of the case, of the appeal, or in some other procedures that are before the case is submitted to the judge and is submitted to the court hearing?
In my opinion, right now, we have quite an improved procedure for submission of claims and appellate complaints. Ukraine has been working on that for a long time. Right now, the e-court system works, so you can submit administrative claim and the appellate complaint from any place. You can also study materials of the case as well from the system. I think that shortcomings exist in the work of those courts which are overwhelmed with the caseloads and that are not able to prepare all the materials for the upload into the system. Also, right now we have mandatory recording of the court process. You can also take part in the court hearing through video conference. So I do not see challenges. These are just separate challenges related to the courts that are overwhelmed with the caseload and which do not have enough judges.
It's the workload, and no other particular shortcomings are existent in the court system. Thank you very much, and I'm giving the floor to my colleagues. John Ehrlich, please.
Dober ranok.
Good morning.
Thank you again for being here. I just have some follow-up questions from my colleagues. You mentioned that when you were working with the Court of Appeals, that sometimes you would see mistakes of judges in courts of first instance that You have just described primarily due process violations, that the judge didn't properly consider or give proper notice. You also distinguished just now in answers to questions from Madam Chair that as a lawyer, if a judge makes a legal mistake, your avenue is to appeal that mistake to the Court of Appeals, if it's a legal error. Are there any circumstances where you see a judge making a legal error, a mistake of law, that should be grounds for disciplinary action?
When we are talking again about the motivation, the denial in access to justice, then here we for sure need to see that this of existence or the absence of degree of guilt and existence of grounds for disciplinary liability. But again, in my opinion, the issue about motivation on the merits can be considered if this decision, for example, is not about this case at all. Like, unfortunately, we have some separate.
You refer a lot to the importance of the service disciplinary inspectors being impartial. How do we, as a commission, make sure that our potential disciplinary inspectors are going to be impartial? How can we ensure that? How do we determine that?
Well, with respect to me, I can say that I act in my professional sphere impartially indeed. I completely exclude any communication about cases that were considered by my judge. And in such a way, it's actually ensured that no one could have an intention to influence me in any way. So I had communication exclusively about some working moments within the framework of the current legislation. And I will also behave in the same manner at the position of the discipline inspector.
So I want you to assume you get this job and you get assigned a case, and the case involves Judge A. And Judge A is accused by a complainant of being influenced by an outside party. There's a suspicion that he has talked to the attorney for one of the parties outside of the courtroom, and he's making decisions not on the merits of the case, but based upon this improper communication. While you are investigating, another judge who is in the same court comes to you while you're leaving work and meets you in the parking lot and says, I know you're working on Judge A's case, but I want to let you know that Judge A is agreeing to resign, and he plans on resigning by the end of this year, and we're going to ask you to please dismiss this case. And then he walks away. What are you going to do about that communication?
Well, first of all, in advance, I will not communicate with the judge at all, even if at the beginning, I will interrupt this conversation at the very beginning. And if it happens, then if we talk about analysis of the legislation, then here the disciplinary inspector cannot notify about some interference with their activities. At the same time, it can also be included into the conclusion, and that is prepared pursuant to results of the preliminary check of the disciplinary case, because I may also submit a motion about the initiation of the disciplinary case. Of course, if I know that other judge, and I can submit such a motion to the disciplinary chamber, because the disciplinary chamber is granted with powers to open the disciplinary proceeding upon its own initiative.
So just so I'm clear, you would consider referring Judge A for discipline because of his is that what you're suggesting?
I believe that it can be included into this disciplinary inspector's opinion because it may be considered as some extra procedural communication as some sort of attempt to influence the disciplinary inspector in order to entice the disciplinary inspector to close the case regarding another judge. I believe that it can be checked.
Would you share your concerns with the people that you report?
After considerable number of years last year and started to work as a private lawyer. Is that right? The reason for leaving the judiciary, please.
For me, that was about development. I believe that I obtained enough experience in order to move further. And really, that helps me to be more competent for participation in this competition as well for the position of the disciplinary inspector, because I have already seen the judiciary and the work from the other side. And that's really important, in my opinion, to have this continuous self-development.
After 1 year, you are basically trying to return to the judicial system in a different role, but it's the judicial system. So you think the mission was accomplished when it comes to personal growth and you can come back to the position of disciplinary inspector enriched. Is this the understanding?
I had the goal before I obtained the attorney's license to have this position of disciplinary inspector. And of course, as the attorney, I'm a young attorney, and I have lots to learn in this sphere as well. But this experience that I've obtained as the attorney gives me more opportunities to be competent.
Thank you very much. My second group of questions, I will start with this one. Please, in your own words, what do you see as the essential role of a judge, in your own words?
The judge's essential role is a fair resolution of cases in compliance with the principle of legality and rights and interests of the persons coming to court, as well as establishing where there was violation of some rights and whether this violation was proportionate to the interference with some specific right.
Thank you. If we take modern history of Ukraine, let's say last 15 years, were there stages, in your view, when judges betrayed their role? Which cases did you notice as the most significant deviation of the ideals you mentioned, please?
Of course, unfortunately, we had such cases. Here I can use only information that is publicly known. That's the period of the Revolution of Dignity, and indeed it was already stated by specific checks regarding judges, and was really established that they adopted arbitrary decisions.
So can you elaborate please more? I asked about the types of most significant deviations from the ideals you explained in the first answer. And for now, as of now, you mentioned arbitrariness. Are there any other violations or deviations from the judge's role you can mention, please?
For me, basically, arbitrariness is the key one if we are talking about deviations from the ideals. On a daily basis, decisions are quashed and violations of rights are established by the courts of the first instance and the courts of appeal. And the European Court is also stating that arbitrary decisions were adopted with respect to the failure to protect rights and interests, and that resulted in the violation of fundamental freedoms. And these cases also existed.
Thank you very much. My second question will be a follow-up on the theme of pressure. You mentioned several times that the pressure sometimes comes from society. Where else the pressure can come from? Pressure trying to influence judges' decision or disciplinary inspectors' decision?
That can be coming from different officials, that can be from judges, and that can also be originating from attorneys and from private individuals. Influence may happen from any side.
And now let's imagine two types of pressure. One is direct. Somebody, superior official, comes and tells a person, you should do this. I really want you to decide this way, even if it is illegal. And then there are indirect types of pressure, when the expectation is clear, what the higher positioned person or even a colleague expect you to do. It is also clear what are the consequences if you go another way, if you don't fulfill that expectation. Direct and indirect. Which is more difficult to deal with, in your view?
Basically, I believe that it's not difficult to deal with any type of pressure if you're sure that you're acting according to the law in compliance with rights and freedoms. And that's why you will actually be impartial in all matters, and no one will be able to pressure you if you are sure in what you are doing and if that complies with the law and the rule of law.
Have you been exposed to such pressure in your past?
I have already mentioned that no, I have never been exposed to such pressure, and it's first of all related to how I built my work. So I fully limited my communication regarding cases which were at that time considered by a judge. So it excluded any intentions to impact on me and to pressure me. And of course, it's caused by the fact that I don't make any decisions because it's under competence of a judge.
Okay, thank you. And if you haven't experienced such pressure, how do you know that it is easy to handle it?
Again, I reiterate that we need to build our working process. So if you limit completely any of your communications with cases under your consideration, with complaints under your considerations, and persons will not be able to pressure you, to impact on you.
Okay, thank you. Do I have time for more, or if we should? One more? Okay, I will pick one from the two I have left. You mentioned in your motivation letter a very important paragraph. The first day of the full-scale invasion of our country by the Russian Federation was no exception for me in terms of work, and on February 24, I performed my duties for a full working day. This is a very important moment in Ukrainian history, and I don't want to hear details about what you were working on, but how was it to work on the very day of the full-scale invasion and fulfill your duties as a regular day? Please.
Regarding this matter, I would like to underline that during the martial law, courts shall not stop functioning. Right to a trial shall not be stopped or suspended, both the fact to submit a complaint or a file or consider it. So that's why the first day of a full-scale invasion, I needed to arrive to work because it's a day of panel sessions when we have some consideration of cases. First half of the day, we even managed to consider a few cases, but then, of course, we were in touch with parties to proceedings, because our court has already included some regions which were already under the start of occupation, and of course it also impacted on our consideration. We needed to issue a document why we didn't have a court hearing, but anyway, we as a team needed to do it because we didn't know what will be next. We needed to complete this working day regarding court hearings to process and finalize relevant documents. And of course, all these documents, all these files are attached to case files. And then when the day is over, we went to homes, to our back to homes, and then we were guided by instructions. Then we continued our work. Our court didn't stop functioning at all, didn't suspend functioning at all. There were only a few days, and it was caused by a hacking attack, which led to our impossibility to work on computers. But then we continued our work.
Thank you. Thank you so much. So I have one more. You worked in the administrative judiciary, which I find the most fascinating part of law, although as a law student, I didn't think so. From all types of cases in administrative judiciary, which types of cases are most prone to corruption, in your view? And why?
Maybe we can speak about court cases related to challenging of decisions of tax authorities and where the sums are high, and also challenging some permits or licenses on construction. I think that these are key categories of cases which could raise concerns on that matter.
Thank you. Our interview, well, the time has run, but I hope you do not have any hard feelings about this, because it was interesting for us to discuss with you those important things that are essential for taking the decision. And also we have a part on integrity and ethics, and if you do not object, we would prolong our interview for like 10 minutes, not more, just to have an opportunity to ask some questions about this part.
Yes, yes, of course.
Thank you very much. So, Pani Olga, please.
Thank you, Reda. So, dear Svetlana, my question is the following. So, yeah, I have actually provided answers to questions that we asked you regarding your property and registration of your property, and some issues regarding your declarations. We have all your answers in your profile. The issue regarding registration of powers of attorney for vehicles. So you fully rebutted. You confirm that the vehicles which are mentioned in our questions, that you don't have any powers of attorney regarding them and so on. Yeah, I fully rebutted. I don't have it. So I have never had either in usage or ownership any kind of vehicles. And if we look in public data, we can see that abbreviation RS, that's Volyn region, and that's the full name in the power of attorney in mine is the same. So, okay, thank you. Let's go back to 2024, when you already started working as attorney, but you received an income from your attorney practice in 2025, and it means that you didn't have to declare your income from your attorney activities for 2024. My only question to you, what were your sources for living? So you did need some funds to live live, to maintain your property, and so on. So what were your sources of income? Yeah, so in 2024, I had my official salary, even if we do some math, and so it was even higher than minimum salary. And I want also to take to take into consideration that my first salary was not that high, so I know how to live for a small salary amount. Of course, I was preparing myself to start attorney's activity in advance. I realized that I would not get some income from attorney's activity from the very beginning. That's why I had some savings. I didn't purchase any kind of property. I didn't have significant expenditures. I didn't have any, financial obligations either in 2024 or 2025 under provisions of the law on corruption prevention. So this is publicly available data, and you can check and you can confirm it. So it means that I didn't have any expenditures which are higher than my income. Okay, thank you. So, dear colleagues, actually, I don't have any other questions. If anyone has, please over to you regarding this part.
Some questions about this part? So, thank you very much. And if you have any final remarks or comments, like 2-3 minutes, the floor is yours for this final observations.
So first of all, I wanted to say thank you for this interview. Yes, indeed, it was an interesting one. I was so anxious in the beginning, but indeed, this atmosphere allows me to answer all questions which Commission asked me. I'm so grateful to you to this. I hope that I managed to prove to you my professional motivation and competence, and it will allow you to make a decision that yes, indeed, I can be appointed as a disciplinary inspector. Thank you.
Very much for preparation for this interview, for coming to this interview, and we will take our decision on the winners of this competition, and we will announce this decision in the morning on Wednesday, the 1st of October. So it will be broadcasted, of course, so you will get to know. So thank you very much and good luck. Добрий ранок.
Good afternoon.
So today we are proceeding with interviews for the position of disciplinary inspector, and we have candidate Pan Mihailo Zolotar. Good morning. You participate in this kind of the exercise not for the first time, so you know the procedures, but let me remind some of the most important aspects of our procedure. So the interview will last for about 1 hour, and the interview will be conducted by our commission. We have 5 members of the commission present today. So I am Rada Moliene, the chair of the commission, and the members of the commission are as follows: Olena Kovby, Olha Popikova, Pavel Zhelinchik, and John Ehrlich. So we will start from your presentation of your motivation, of your professional qualities, and then we will ask some questions about your professional experiences and competences, and then some questions about integrity. At the end of the interview, you will have several minutes for your final remarks. And our interview is broadcasted. So if you have any information during the interview that falls under restrictions for its public disclosure according to the martial law, please let us know and we will take the decision accordingly. Would you have any requests so far? Or any remarks?
Дякую, поки немає.
No, thank you. No request.
Very much. So the floor is yours for your presentation of your motivation. Why are you again participating in this competition, and what professional competences allow you to be here and to apply for this position? Thank you very much. So you have up to 10 minutes to do so.
Доброго дня ще раз всім.
Good afternoon again to everyone. Last year, indeed, I participated in the competition. I told you about my motivation. It's the same as it was last year, and it's complemented
До цієї мотивації додається те, що суддя, з яким я працюю,
by the fact that I'm assistant to a judge who is going on retirement because of his age. So he reaches the age of 65 years old. It means that I need to look for something new. I wanted to try myself at the role of a disciplinary inspector because I know this work. Last time I already told you that when I worked in the HQCJ, we have already considered such disciplinary proceedings, and as an HQCJ inspector, I provided such findings and I considered such disciplinary complaints. Then, when I worked at the Supreme Court, a judge with whom I had worked, he was delegated, he was seconded to the Grand Chamber. So the Grand Chamber reviews decisions of the HCJ, and as it was under its jurisdiction, so they reviewed the decisions of the disciplinary authority. So it means that we have, I, as involved into this process, I have been in all the stages, so I know what to do. I know in order to check whether there are signs of disciplinary offense, how to draft a decision, how to do it in a proper manner in order for this decision not to be cancelled on the second stage and returned back for the repeated consideration. So this is my key motivation to participate again. So, and of course, last time I failed. That's why I would like to try again, maybe to realize why I failed last time and maybe to improve my situation.
Indeed, we had an interview a year ago, and we asked some questions and we had a discussion with you. So today, probably some of the questions would be the same or similar that we asked last year. But as those who are watching the interviews, maybe some of them are watching for the first time, so they have to hear your position, your answers, your responses. And also maybe some other aspects will be revealed during our discussion. So we will ask our questions, new ones and maybe some previous And I would like to give a floor now to Olha Popikova to start this stage of questions, answers, and discussion, and we will proceed. Thank you.
Good afternoon, dear Mikhailo. You have already mentioned that that's your second participation in this competition. Tell us, please, what's your experience that you gained during the previous participation in this competition for the position of discipline inspector? Into your opinion, what's the reason that you didn't win on the last competition? So the experience which I gained is the following. So I have never participated before in such competitions, including public competitions. It was also first time for me to pass the cognitive test, and it was an interesting one for me. It was a new thing for me. It showed to me my drawbacks, which I have to my opinion, then practical assignments and open interview. It was everything new for me. I had never participated before in such, public interviews. Regarding your question why I didn't win, I can't answer. I don't know. Maybe there were some stronger candidates. It was your decision to make. Maybe you know better. Why is it so? Yeah, maybe. But to your opinion, so you don't know, yeah? So my opinion, yeah, that's a competition, and competition envisages that the strongest ones would win. So maybe at that moment there were stronger candidates who had more advantages than I had. That's maybe this is the reason, because I don't see any other concerns or issues. Okay, so you were quite short in your motivation letter. And Madam Reda suggested to you to give some time for self-presentation. You used it to present your motivation, but maybe you can dwell upon your personal motivation right now. What's your personal motivation to participate in this competition and take this role of a disciplinary inspector? Because if we are brief in wrapping up of your motivation, that's that you have relevant experience which could be useful, and the second motivation that your judge goes on retirement, and it means that you could be left without your job, without your position at all. So what about your personal motivation? Do you have this personal motivation which was the ground for you to participate in this competition and your wish to take this role? My personal motivation is the following, that I, as major part of my colleagues, I would like to contribute to the system, and disciplinary inspectors is a crucial element of the system, because a disciplinary inspector, is like a working horse who works all the time. He's the first one, or she is the first one, to look at this complaint, to review it. A disciplinary inspector has huge responsibility to study in detail case files, to prepare a detailed findings, to submit them for HCJ, for HCJ to consider these findings and to agree with it. To my opinion, such people, such disciplinary inspectors should be so professional, and this professionalism impacts on so many things, because the law defines a very short period of time for consideration of those disciplinary complaints, and it's a question of a competence of disciplinary inspector to see whether indeed there is a problem or there is no problem. And at my practice, we have considered many cases. 50% of cases are not typical. They are more related to some personal insults or accusations, or we do not agree with judicial decision because of some legal situations. But if there is indeed a disciplinary offense, we shall pay attention to such cases, and then we shall look at such things, because when judges look at such decisions and understand that this is this and this, we shall pay attention to it. We shall not make decisions like this, because we could be brought to disciplinary responsibility. Okay, thank you. So when you underlined the importance of a mission of the service and the importance of functioning and establishment of the service, that's good. Okay, I've got your point. But again, my question, what's your personal motivation to join the service of discipline inspectors? That's some kind of growth, promotion, because I had worked at different positions in court, starting with the district courts and going higher. So there is no single position in a court which I didn't have. And you also mentioned that maybe I will be left without a job. No, that's not true, because for a person like me who have been working for such long periods of time, I would have this job. So you mean that there will be some judges working to work with me? Yes, that's what I mean. But I want to grow. I want to grow and apply my knowledge, my lens of perspective. So you evaluate it as your career growth. Yes, indeed, it's career development, it's career growth, which allows me to grow. Okay, now you work in the Administrative Court of Cassation. Yes, Supreme Court. Yes, you're right. And you had also worked in the Grand Chamber. Isn't so? Yes, I had worked. So it means that we can say that you are somehow related to the case law of the Grand Chamber, because you know the case law of the Grand Chamber, which also reviews and reconsiders decisions of HTJ specifically regarding disciplinary complaints. To your opinion, why do we have so many decisions of the HLJ, including those to bring judges to disciplinary responsibility, which are cancelled by the Grand Chamber? To my opinion, there is they lack relevant argumentation or justification. When judges challenge, it's a very interesting category of cases, because we have judges from both sides. A judge is as the one who made a decision, and another judge who actually complains. And it's a very interesting situation. Always, when we reviewed such cases, we took into account that a complainant was a judge. And again, paying attention to your status, and if a disciplinary authority reviewed this case as a disciplinary chamber, then as HJ, and they didn't agree with it. And as you know, according to the law, HJ should have 21 members, and they have a huge team of lawyers. Why they didn't see it? Why they didn't agree it? And also, the Grand Chamber consists of 21 members. Why they think differently in comparison with lawyers or members of the HJ? So that's the question. And very often, such cases are being considered for a long time, specifically because of such discussions. As an assistant, when I prepare such documents, such findings, we consider them very carefully. We dwell upon details. We request for information. So I prepare my findings. Then I report. I speak out my position. Then you just have a discussion with your judges, with the judges. You try to convince them why you think that your position is right. I'm trying to recall the latest case, but it's still an ongoing case. No, if it's an ongoing case, please don't share the details. I don't remember, because in the cassation court there is so much work, the workload is so high, and you don't have the time to follow up the cases. But the case was very interesting. And we have so many cases like this, decisions like this, recently. And depending on the position of the Grand Chamber, it will impact on the pattern of consideration of such cases. So we were rapporteurs on the case, but we didn't consider it completely. Just remind us, what are the reasons to cancel decisions of the HJ, a part of some official reasons, signature zone? Usually that's lack of motivation. Lack of justification. So complainants who are judges very often in their complaints say the following: that they have provided their argumentation, but HCJ didn't assess their arguments in a proper manner. But yes, that we have a discussion ongoing, because the decisions of HCJ contain some justification or motivation. There is no such situation when decisions of HCJ have any justification or motivation at all. But Grand Chamber thinks that this motivation is different or is wrong. Yeah. So it's present, but it's not proper. So, but you are speaking about lack of motivation at all, or lack of proper motivation. No. I would say lack of motivation or justification. So let's go back to my work at the Commission. There were some decisions of the Commission which contained only figures. For example, a judge received this score, that score for integrity, for professionalism, for competence, and the total score is this. And it, as a result, it allows to go further or do not go further to the next stage. Yes, that's competition procedures. But the law envisaged the Commission to provide also some motivation or justification. And to my opinion, I think the decisions of the Commission should also have contained some justification of why a judge passes this competition procedure or not. Yeah, and I was right. There are some decisions issued by the HCJ which were later cancelled. So yes, indeed, you're right. HCJ decisions have their own argumentation, but I think that arguments used in their decisions shall be very clear to everyone, to the society, to the judge, to the complainant, to everyone who reads them through. Okay, I've got your point. Tell me, please, to your opinion. So, the service started functioning. It works, it has been working for more than a year. But now, right now, we are observing quite a significant number of complaints against disciplinary inspectors. To your opinion, how we can prevent it? And why is it happening? I don't know the statistics of such complaints. It's the first time ever I hear about such complaints against disciplinary inspectors. But we need to look at the essence, at the motivation of such complaints. If you can tell me these details, I will give you my opinion. So, disciplinary inspectors are civil servants. And it means that there is an option to challenge actions of civil servants when they do their work. But okay, if you don't know this on anything on this matter, then I'm not going to dwell upon this question, because it will not be a successful discussion. Sorry, if I may, I will comment. If it's related to labor discipline, no. I mean when they do their job as disciplinary inspectors. Judges sometimes complain that terms of consideration are violated. So there are different issues. If I may, I would like to underline there are so many complaints against judges because the period of consideration of cases is violated, or period of any consideration of any kind of motions is being violated, and so on. The same, when we have complaints against judges, those issues will be raised. But what do you think? Is it possible to consider submission of a complaint against disciplinary inspector as some kind of pressure against the disciplinary inspector? We need to look at the essence, at the content of such complaint. But of course, if I'm a judge, I mean a judge against whom complaint was submitted, yes. So if I'm a judge, I would opt for different options. If I see that a disciplinary inspector violates some rules, some periods, some deadlines, and so on, that I would indicate it. I would show that it's done incorrectly, or I don't know. So it means that a complaint against a disciplinary inspector as a protection measure. I just don't understand why they do it. It doesn't give them anything, because let's imagine, sorry, let's speak slower.
Yes, sorry. If I would not ask to recuse this inspector. Why? Because it is possible only related with the delay of the time, because the law stipulates the term for bringing to disciplinary responsibility and consideration of the proceeding itself. And I see no other grounds. Recusals are also submitted with respect to inspectors, but they will redistribute it and it will be submitted to some other inspector. If the opinion is ready, it doesn't take that much time. I would like to tell you that according to practice, and recusal motions for inspectors are approved not that often. So we are not talking about redistribution because there's also a very serious and sensitive matter. It is necessary to have grounds to recuse the inspector. Yes, I agree with you. And that's why I would like to emphasize that when the judge is submitting a complaint, it is necessary to provide such arguments that members of the chamber would be able to see and to say that yes, that was the case when the inspector should have been recused. And I would like to emphasize that judge choosing this as a means of protection, then this judge is not abusing the right, but it's not appropriate for a judge. Okay, tell me please. If you are interested, I hope you are interested in the work of the Service of Disciplinary Inspectors, we can already talk about some positive moments in the work of the service. At the same time, tell us, in your opinion, do you see some problematic issues in the work of the Service of Disciplinary Inspectors nowadays? And if yes, how are you ready to address them in case you join the service? What I've seen is that again and again terms for consideration of complaints are being extended. I understand that the workload with complaints is huge, but it is necessary to do something with that. Which steps? Maybe again it is necessary to consider the priority. I'm talking about my experience. It is obvious whether the complaint contains some signs of disciplinary offense or no. I would review all the cases given to me, and I would divide them, like some would be put aside at once, and if there is a complaint, it is necessary to send request to see whether it is confirmed or no, because during the check you clarify some circumstances quite often that are being explained, and then you understand the situation better, and you understand whether you have something to use as the argument. Do you see any other problems apart from the workload? Again, it's related to a huge workload, and not all vacant positions of disciplinary inspectors are filled in. Okay. I have two more questions. More professional oriented. How can we establish the intent of the judge during committal of some disciplinary offense? What is the difference between intent and negligence? A judge is doing that, a person who is committing this disciplinary offense is doing all of that, being aware of that. And negligence is caused by some mistakes, and how can this be established? That's not that hard to establish that. If we collect some materials or circumstances, if you provide some case study, I will tell you how I see that, because I've worked for over 20 years, and when you work with papers, I like working with printed out materials, because you feel the energy of the complainant even, and you understand it. And when you're reading this decision, because quite often that is about some specific decisions of the court, or about a ruling, or some court decisions in the form of the decision. And then you see that if the judge is working for 20 years at the position and is making a mistake that should not have been made, then it can show that judge is doing that intentionally. Are you answering this question based on your experience in the Higher Qualification Commission of Judges when you were the disciplinary inspector then? No, in general. Okay. Colleagues, I have last question in this block. Tell us, please, under which circumstances can the disciplinary inspector submit a suggestion regarding combining disciplinary complaints into one case? When the same judge, when during the study of the materials you see that complaints concern the same cases, for example, where the judge adopted a ruling and then there is a complaint against this ruling and then there is a complaint against the decision under this case, I would suggest to combine them. But what if different corpus delicti of disciplinary offenses are there? I would still combine them because it concerns the same judge and the same case. I see no sense in wasting time on considering that through different disciplinary inspectors or disciplinary chambers. Okay, thank you. And I'm passing the floor to my colleagues. Thank you. Pavel.
Thank you very much. Good morning.
Hello.
My first question relates to your understanding of the role of the judge in society. Please, in your words, what do you see as the essential role judge plays in society, in your own words?
You know, a judge, the judiciary is a separate branch of power, not accidentally, and that all life and problems of people are coming to court, and problems of the country come to court. Everything goes in the same direction, to the court. And when all of these problems are resolved, they are resolved either by a judge on their own or by a panel of judges. And these people considering these problems should be the role model trusted by the society. Because quite often we have a case with respect to challenging of results of the election. Everything goes to court. And then maybe even the political destiny depends on that. And all of this is considered by ordinary people on the one hand, and at the same time they are judges. And it is not an accident that they are wearing the robe. They are not gods, but they have to be an exemplary role model so that the society trusts them. And right now we have an ongoing discussion about the distrust, high level of distrust, but there are many judges who work very productively. There are no concerns about their work, but no one is talking about that. We had about 8,000 judges in Ukraine, but surnames of judges who are public is a very small percentage, and if we are talking about this percentage, then we will have this relatively low indicator as compared to other countries even. But for some reason, in my personal opinion, not much attention is paid to that in the judiciary, because there is no communication, no openness, so that all of this is clear, and so that the answer is given. Because quite often the mass media intentionally or not intentionally criticize the court and make this criticism in such a way that it exceeds the boundaries of criticisms and becomes offenses. But the judiciary is not responding to that, and that's very sad.
Thank you very much. So you defined, in your words, the role of a judge. If we take the modern history of Ukraine, let's say last 15 years, were there stages when judges betrayed their role? Which cases did you notice as the most significant deviations from the ideals you mentioned about the role model?
The biggest betrayal happened during the occupation of our territories in Crimea and in Donetsk and Luhansk, and some judges stayed on those territories. And some judges even started cooperating with the occupation authority. That is the biggest betrayal. And with respect to other instances, many judges leave the system because they cannot cope with their workload. I've mentioned the figure of 8,000 judges, and I don't know, if I'm not mistaken, we have only about 4,000 judges remaining, right? In the system, and so it happens that all the workload is placed on these judges, and no one is taking that into account. That's unreal workload. Like judges have the case materials at this level of from the floor, and they cannot physically consider them. Even if you give 2 free assistants to them, they will have no time to physically attend all the court hearings to consider all the cases. It is necessary to fill in vacant judicial offices in the first instance in the Court of Appeal. We have the issue with the Supreme Court. The workload is increasing because some judges retire due to age, and the competitions are not being conducted.
Why do you see the judges leaving because of the workload as a failure or betrayal of their role, if I understood you properly?
That's roughly speaking a betrayal of the profession. That's like the betrayal of the profession.
Чому?
Why? There was a discussion ongoing at some point when I used to work in the district court. The workload was increasing, and some judges were saying, I see no point. I'm spending all the time in the court. My family lives its separate life, so I don't see my family, because really you come to work at since 8 a.m. and you work till 9 p.m. and my children are graduating from the school, and I did not see my children growing up. And an important factor is salary as well, because judges receive not that high as a salary as compared to the average statistics, even despite the fact that the legislation has increased the remuneration, but in reality these amounts are not that high. If we compare that to the US currency exchange rate, that is about $1,500, and that's not that much for such a huge workload. And the quality suffers from that, because it is also difficult to find the assistant who will agree to work for free for $100.
So the fact that the judge has a very difficult time to continue because of all these circumstances, the work, the lack of judges in the system, low salary, and he or she decides, oh, I don't need this, I will do rather something else. You see this as a betrayal of the role?
Yep.
Sorry, I was talking and I did not finish my point. Because of this high workload, some judges wanted to stop working and to submit their retirement application. And colleagues were saying, that's what you're saying, betrayal. Do not betray your profession, because when you started working in this position and when you worked so long, please do not leave this pathway, because other young judges are looking at you and they work less. And if you leave, it will be a signal for them that, look, people cannot cope with that, you have to leave, there are better circumstances, it's better to hold some other positions. That's the context.
So you mentioned 2 types of betrayal of the role. First was the occupation, Donetsk, Luhansk, Crimea, cooperation with the enemy, and then this leaving under difficult circumstances, leaving the job. Are there any others you would mention in the Ukrainian history, other types of failing fulfilling judge's role? Significant, serious types?
That was also during, there are some notorious judges who were considering the category of cases regarding political activists. And because of these court decisions, these political activists were imprisoned. Sometime later they were released because of the decisions of the European Court, because of the change in the political environment in the country, but there were judges like that. We have such instances, unfortunately. It's a pity to say that, but we do have them.
Okay. My next question concerns possible pressure. We would like to live in a country, we all, me too, in a country where judges and disciplinary inspectors do not feel or face pressure, but sometimes it may happen. In your view, which type of pressure is more difficult to handle? The direct one or the indirect one? When the direct one is somebody comes to you and expresses his or her wish that you handle this case and in my view you should do this and this. The indirect way is implicit. It is not said this openly, but it is clear that what is the expectation, that if you do not follow that expectation, it will harm your relationship with that colleagues or with that superior. The consequences will not be positive. Which of these two is more difficult to handle?
In my opinion, that's personal pressure. But the peculiarity is not because of me personally, but through relatives. Quite often they use pressure through very close persons. And I would not want them to have pressure. I'm talking about children or parents if they're alive. That's the kind. We have such stories, unfortunately, again, that they try to influence, and that's very hard.
I'm not sure I got the answer to my dilemma. I mentioned the direct, you should do this and this, and the indirect, this is not said. And your answer was the most difficult is to handle the personal pressure, for example, from relatives. Do you mean the direct one or the indirect one? Or it is a third type of pressure?
I would call it personal, because they are pressuring you personally. That's what you are calling indirect pressure. That's very obvious through the legislation. For example, the disciplinary inspector has a specific salary amount defined by the law. But quite often, while adopting the law on the state budget, it is possible to decrease this salary amount. And for example, one of the motivation is also to increase the salary. And one of my motivation is that the salary of the inspector is higher than the one I'm getting now. And they will be adopting the law for the next year budget soon. And one of the motivations when I was applying for this position will, for example, disappear if they decrease the salary amount. And that's why also judges also do not receive high salaries, because the very low subsistence minimum is applied to their salary.
Okay, for now, that's enough from me. Thank you.
Дякую.
Thank you.
Good morning. I just have a few questions. In response to Pavel's question, you said that a judge has to be an exemplary role model. How do you define an exemplary role model?
Just recently, a judge, U.S. judge died. I don't remember his name, but he participated in court sessions where he used very simple language while explaining to parties to the proceeding why they were brought to responsibility and what is the reasoning for decisions made by court.
Any other qualities that you see in a judge being an exemplary role model? So you were giving me this example of a judge who explained things to the parties so that they could understand them. Any other qualities that you would describe for an exemplary role model for a judge?
So an ideal judge, the same as in court and beyond the court, shall correspond to the status. He should be ideal everywhere. But of course, we are human beings, and unfortunately, it doesn't happen everywhere. So, speaking about ideals, what should be the role model when starting with the court session and ending with a decision issued by a judge. So you as a party to the proceeding, you shall be sure that you are heard. And very often judges violate such things. For example, a judge appoints a meeting for 11 a.m. You come to 11 a.m. and a court session doesn't start at all, not because of objective reasons, but because a judge just late, drinking some coffee, tea, or handing some of her personal stuff. I think that it's showing huge disrespect. And if I'm a party to the case and I'm waiting for a judge for such long time, and this judge comes and she just had her nails done, and of course that's not a reason, for being late. And this where the point where distrust starts. So if a judge doesn't show respect, or for example in court hearing, rules of procedure define a period of time for your presentation, but if you don't finish within time, it would be great to give some time to a party to finish their point. And very often it's not given this time to parties to the proceeding. And finally, judge says you will get a decision which all justifications, all motives presented there. And when a party to a case takes this decision, they read it through and they don't understand why. Why is it so? Why do they get positive or negative decision in this specific case? And then this party to the case goes to a public event like football or theater or anything like this, and they see this judge in some, unethical situations somewhere on the beach or somewhere else. So it should not be like this. And a judge should correspond to this ideal everywhere, starting with court session and ending with private life. And when you see this judge and you respect it. I know another example, a district court. There was a judge, and she had been working there for long periods of time. She had considered only criminal cases, and those suspects who were convicted after their conviction periods ended, they actually approached this judge saying thank you, that they realized why they were convicted, why they received these convictions, those charges, and they now understand why, and they improve themselves. That's the ideal which is worth of respect.
Thank you. I have quite a few more questions, but I know we're limited on time, so I will turn it over to my colleagues. Thank you very much.
Thank you. I found your response to Pavel's question about indirect and direct pressure, and your response was about the decreasing the salaries or cutting the budget for disciplinary inspectors as possible indirect pressure. And indeed, it's a very complex issue when we are talking about the relationship between executive and legislative and judicial power. And the decrease or reducing the budget for judiciary. In your opinion, could be there situations when this kind of a decrease of a budget could be perceived as in compliance with Constitution and not jeopardizing the judicial independence and independence of judiciary? And what kind of situations would for sure be considered as a threat to judicial independence? Would you see differences in some situations when it could be like legal and illegal, so to say?
Щодо заробітної плати,
Regarding the remuneration and salary,
яку я озвучував,
the example which I mentioned, it was a subject of a case which was challenged. So judges actually stood on the side of civil servants, and recalculation now is done. So I explained it as one of the elements of pressure.
наприклад, можна ліквідувати
For example, we can liquidate a court. So in order to do it, a presidential decree shall be issued, any court could be liquidated, and it will be actually a political pressure against this court. So that's political pressure against the judicial branch. So you can reform, just decrease any facility, and because of such reforms, actually it could lead to destroyal of the whole purpose of this function.
Faces a critical economic crisis or a war. So could be there situations when this reduction of the budget could be considered as in compliance with the Constitution and not be considered as a threat to the independence of or the impact on the judiciary.
So, of course, so now we are living amidst the war times and we have huge problems with the economy, but all these changes shall take place in the legal field. So, speaking about the judges, the guarantee of judicial independence is also covers judicial remuneration, and it's regulated by specific certain law. All amendments shall be made to the law or through this law. If the state thinks that remuneration shall be decreased, they have all possible reasons to submit, for example, relevant draft law to the Verkhovna Rada to consider as a specialized law, and there is no problem at all. No, I'm speaking about another thing. When it's done secretly, or for example, with this case of a judges, when remuneration is decreased, but by not through making amendments to this certain specialized law, but through other things, through other procedures, through application of subsistence minimum.
Also, you mentioned that you participated in the previous competition, and it was the first time participating you in this kind of public competition. And indeed, this is quite unique in Ukraine that this kind of competitions and interviews are broadcasted with candidates. Usually, it's not in most of the countries. What is your opinion? Why it is done, and if you find it appropriate and relevant to do so? What is your opinion about this publicity of interviewing? Because it's quite a stress and quite a difficult situation for candidates. We do understand this. So, what is your opinion about this publicity and why it is so?
Nowadays, when we have a huge distrust to judicial system, such competition shall be open, public, transparent for everyone to see how interviews take place, whether they are staged up or not, how candidates pass them, what questions are asked. Such broadcasting records could be seen later, anytime, because they are stored in internet forever. I don't think that this role is such a high role which requires such high publicity, but in my opinion it's a right decision. And because it was a newly established service, before its establishment, there were so many different arguments, discussions, amendments were made to legislation, and the public actually related to the judicial branch, they follow those discussions and amendments and so on. And there were so many questions from the side of the public. Why candidates who have passed some stages before the interview stage with the HCG, they just terminated their participation in the competition, or why is it happening like this? So such open competitions could give some understanding why was it so. Mike.
I found interesting your remark that this position is not so important, but do you consider it's not so important as other positions that are the competitions to which are held publicly.
І я кажу про
No, I'm speaking about open public competitions. So I mean public broadcasting only in this regard. And yeah, so it's for sure that all competitions should involve experts. I'm speaking only about publicity and broadcasting.
But I will keep it if we will have some time. I'm passing the floor to my colleagues.
Якщо
Thank you.
можете, я закінчу ще
If I may, then I will finish regarding the previous question, because this role is considered as the category B role. So it's not the highest role in the general architecture of civil servants' roles and positions. That's why I think that it was not that high to show the high publicity if there was no request from the public to show publicity. Thank you. So, dear Mikhailo, I had only one question, but I'm going to ask you two short questions to follow up Reda's questions. So, frankly speaking, I didn't get your point regarding unimportance of the position of disciplinary inspector. So, as you have said, that this position is not that high. What do you mean saying it?
в нас є категорія
So, we have different categories of civil servants
категорії державних службовців.
positions. So we have category A, these are managers of units, and for these positions we don't have such open competitions. And here I'm meaning that we have a disciplinary inspector which belongs to another lower category, but we have a huge demand, societal demand, to have a competition being open. Why is it so? Because this service which helps to build trust to judges. So do you identify importance of a position by category A, B, C, or of this position in civil servants architecture system? No, let's take an example. So you have a vacant position of the head of apparatus. That's a category A position, but there was no competition at all with involvement of any experts. Why? Why wasn't there any competition at all? Sorry, I didn't get your question. So you said that at the HTJ there was a head of secretariat appointed, but there was no competition. Why there was no competition at all? No, I'm not speaking about having competition or not having competition. I'm speaking about open competition. So I just work in the system. I know that there was a change of a head of secretariat, and I found out about it just by chance, accidentally, when I've got some documents. Okay, another follow-up question. So regarding judicial remuneration, so you call it salary, but it's remuneration for judges. So now you say that nowadays judges satisfy lawsuits of judges to recalculate judicial remuneration. And what was the final decision of the Grand Chamber? No, I understand the difference between salary and judicial remuneration. I fully understand it. Sorry if I just called it like this, it just slipped out of my mouth. Regarding the latest case law of Grand Chamber, I don't remember such cases. No, I can't recall it in my memory right now and can't give you a reply. So the practice of Grand Chamber has changed on this matter for the benefit of judges or not. So the position So the position of calculation is still to have this calculation of remuneration is the same. Okay, let's go to the next part. So I have a question regarding you as a person who is obliged to have military duty. So you have provided us with military ticket, which says that since April 2007 you are registered in TCK, in Solomensky conscription office. But now, during our verification of your documents, we have received a very interesting reply from the Solomensky conscription office saying that you have been registered that you have not been registered in any conscription offices and you need to reach them out to update your documents. Do you know about a duty of each person obliged to military duty to reach out to conscription offices and to update their documents? Do you know that you needed to do it last year? Yeah, you're absolutely right. I have fulfilled all provisions of legislation. If I may, I develop on details. I try to explain it in my written answer. So back in 2022, at the end of February, I voluntarily reached out to the Solomiansky conscription office because I'm registered at the city district. So the employees of the Solomiansky conscription office, they saw my data and all my information, and as I have no military experience, I was referred to serve in the Solomiansky territorial defense forces. But when the active phase of hostilities in the Kiev region finished, so I started to work here in Kiev, and I had deferment. And there was no problem at all, so I had deferment when I updated my data. I updated my data through SNAP, so that's Administrative Services Office. I have an extract from SNAP, but you didn't provide it with us. I can provide it right now. So I know the story, I know the station, so all my data was updated. And we have even a conscription unit in my court which is responsible for all the things. So just last week I collected all documents. Each year, each quarter, they just review all documents and just align all documents regarding each person, each employee of the court who is obliged to serve military duty. Regarding me, the Solomiansky conscription office has no problems at all, has no concerns at all. So as of now, I found out the following things. Half of the personal files was destroyed at the beginning of March because of security reasons. I'm from Zakarpattia, and at the very beginning, Hust conscription office was that's the place where I was registered at. But at my military ticket, I have been registered there since 2007. So do you use Reserve Plus app? No, I don't have it. You are not interested in what's happening there. No, it's not that I'm not interested. That's I have all certificates, all documents. I don't use so many apps in my smartphone. Okay, if I may ask you, please provide us with this extract from SNAP, from Administrative Services Office, regarding your status as a military conscript.
Sorry for the condition, because I'm carrying it with me all the time. In the Territorial Recruitment Center, I was told that I had to address them again with this data from the mobilization department that I've taken, because they were checking and there are no comments regarding that, and they're saying that's really a surprise that you are not in the database. And I was explained that it concerns the Kiev region and Kiev only. And since here it is said that they made a mark here later that that was this Territorial Recruitment Center of Hust. Okay, thank you. I have no more questions.
As we had interesting discussions, and our interview is... Oh, sorry, please. Do you have interpretation? Oh, okay. So our interview has ended the time of the interview, but as we had this interesting discussions, and we already integrated part of our integrity and started those questions about ethics, integrity. So we will proceed. If you agree, we would prolong our interview for 10 minutes, and we will have 2 or 3 questions for you. Okay? Thank you. So I am giving the floor to maybe Pavel. Yes, please.
Thank you very much. I will be very brief, and please, I ask you to do the same with your answers. But there are two questions. I owe you one question, and the second question I owe to myself to make a proper decision. The question I owe to you, when you said that the intent of a judge is quite easy to determine, you said, you tell me the scenario and I will tell you how I would do it. So here is the scenario. A very powerful figure in a country is driving a car. He hits an elderly lady and the lady dies. He calls the police and says, "Oh, the lady died. We killed the lady." And there are witnesses who saw him coming out from the driver's seat and trying to save the lady's life. Surprisingly, in the criminal case, the wife of the important person who was sitting on the passenger seat says, "I was driving." The driver says, she was driving, sorry, I correct myself. The man says she was driving, so they provided consensual claim. My wife is responsible, and she accepted this responsibility. The judge, and now we don't know whether intentionally or not, disregarded all the evidence in the file provided by the witnesses and sentenced the woman with a very mild sentence. How would you, there is a disciplinary case against the judge because she disregarded many important facts from the file and sentenced the wrong person, the claim says. Wrong person because it contradicts the witnesses' statements and the recording from the police call and so on. How would you proceed? I don't want the answer whether it was intent or not, but how would you determine whether she did so intentionally or not? Just to please the powerful person, to make her life easier, not to have a high-profile case, and so on and so on.
While considering the case materials, that will be a criminal case, and if there are obvious evidence like testimonies of witnesses, and quite often we have video surveillance on roads, and if it is obvious that this influential figure was the driver, that is the man and not his wife, and if the judge ignores that in the court decision, that will show that it is not a mistake, that's obvious intent.
She will say, well, that was my understanding. I just had two people who said she did it. I wasn't there. And yes, there were some witnesses, but it's my right to evaluate whether I trust the witnesses more than those who actually claim consensually what happened. What would you say?
If that concerns witnesses only, I would like to repeat again about video surveillance. I would send requests to see how the vehicle was moving, and it would be obvious because the face.
Ну, це тоді.
Then it's upon discretion of the court, and we cannot assess if we have only witnesses, and then the judge assesses that one witness might say something else, the other witness might say something else completely differently, and that's upon discretion of the court, and we cannot talk about intent, and it is very dangerous to interfere with this discretion. We cannot do that.
Okay. So you say that it would be upon her what she says and how she evaluates the evidence. And if she says, oh, I trusted these two persons, not the witnesses, then the intent is off. Or there can be, or something can be done to determine it further. I don't know. I am just trying to walk the path. You said, give me a scenario, And I'm already satisfied with your answers. This is just an additional follow-up, whether this would be the stop or whether something can be done. And I don't know if something could be done.
Can you please clarify? I'm just not very sure what you said. Can you please clarify?
I think we don't have time for that, so I will stop. I think you provided your answer. I understood, and I didn't have a right or wrong answer. I just wanted to see how do you perceive the intent issue, which is, in my view, very important. Now, the second question, I still ask whether I have the right to ask. Thank you. When you mentioned the pressure, you mentioned the personal pressure. What would you do if that happens?
I don't know what I would do. I would not want to be in such a situation, in fact, because that is a very thin psychological line that can break anyone, any person. And you know, when people are selected for the position of the judges, stress resistance is one of the criteria. And this stress resistance means one thing in some situation. We have been in the war condition since 2014, but when we are talking about February, March, April of 2022, they were the months when some people whom I respected, whom I believed to be some role models, they showed their negative sides. And on the contrary, those people whom I did not pay much attention to, ordinary people, displayed themselves to be heroes. And this critical situation showed the true nature. And you see then the essence of the person. But in this situation, I'm not ready to tell you. I will lie if I would say that I would be such a good, I would do that and that, because I don't know. I cannot answer.
Very much. That's all from me.
Okay, colleagues, let me continue. We have the block about financial integrity left. Let's take into account the fact that the candidate is taking part in the competition for the second time, and we studied many of the issues regarding property and financial integrity during our last interview. Over this period of time, as far as I understand, you have not acquired any new property. At the same time, sorry. From your detailed answers, it is clear that that you are explaining that funds for the purchase of property by your family were mostly given by your relatives. I mean, by your father and by the family of your, should I say, cohabitant or former wife, ex-wife, common law wife? Because as far as I understand, you are not married anymore, but you live together right now, yes? Yes, you are divorced, yes, okay. Maybe ex-wife. It sounds a bit more sensitive. Do I understand it correctly, that the key sources of funds were given to you by the parents? Yes, because when I started working, we did not have income. The peculiarity, I'm from the Carpathia region, and the peculiarity of the region envisions that everyone is working abroad, all over the world, earning money. And my parents are not an exception, my father in particular, and my ex-wife's parents. They have been working, and these funds have been accumulated in some strong currency. In our case, it was the dollar equivalent. We were always saving money in dollars. And the funds were accumulated, and they are helping their children in order to start to live their lives. Okay. As far as I understand, the matter of confirmation of these funds, I mean the funds received abroad. You said that they worked in the Czech Republic and somewhere else. Did they receive these funds in cash? I mean, for the parents' work? Yes, mostly. No, through bank transfers, etc. So just to have some confirmation. So the story exists for sure that Ukrainians went abroad to work and get money there. So you do not have any confirmation. And I cannot have this confirmation because for security purposes, usually no one declared, I mean orally, no one said who was earning what security situation. Not to lose this money because we had bandits taking away money while people were going home. It was a very prevalent phenomenon that while you're returning home, you can lose all the money that you've earned over the year. People work in Slovakia, Czech Republic. Did they work officially there? Your father? You mean officially how? Signed labor contracts? How it is happening? Abroad, there is an employer who is looking for workers. Mostly these are civil works. So they invite any employees. Then they prepare documents for this worker so that the worker could live there legally because work. Because if on the territory of foreign countries, for example, the police comes, then these workers are deported, and they are deported for many years, and they cannot work. So most workers work with official work visas. And the amount of the salary, how much you are getting, all of that depends on the competence of the worker. It's called in our region like client. This client has a legal entity, a company that is providing services officially, and then this company is hiring anyone, either subcontractors or just as workers. And for example, my father worked for such a man officially. He had all the official documents that allowed him to live there, stay there, and work there. Okay. At the same time, I have the following question. Owning residential premises, in particular an apartment, since 2011 you have been registered in a dormitory. What is the point of your registration in the dormitory? There is no sense. I want to sell the real estate object and to buy a larger apartment so that entire family could live in that apartment or house. But you can do that while being registered in your own apartment, yes. But then I will need to cancel my registration, and then during the sale it will be a problem. Right now I have ongoing consultations. I want to sell an apartment, and that is one of the first matters. Did you used to live in this dormitory where you are registered? I was registered there because when I worked in the district court, when I was hired there, I was registered in Kyiv as a student. And back then there were no issues. And later, when I changed my registration after graduation from the university, the management of the court said that I did not have a registration. And then there was a letter from the management of the court with a request to register me on this dormitory. I was not given any room. I've never lived there. That was just registration that was necessary for me to work in the court. You did not get service apartment. No, I did not submit any application or anything else. Okay, thank you. Colleagues, maybe some of you have any other questions. If you allow, I have a question. Your explanation sounds very strange. Your father was officially registered because it was the only way, but he got the salary in cash, so he did not pay taxes from this income. Or how did it happen? Look, in order to get a work visa, I understand that. It was necessary to get this request from the legal entity. You've explained that already. I'm asking about the salary. Why was it paid in cash? I don't know how it was happening. I know that my father was bringing cash home. In response to Olga's questions, you said that he was receiving money in cash. I don't know in which form. Of course, not through bank transfers, because my father did not have bank accounts in the Czech Republic. He did not have any open bank accounts there, and I understand that he could not get money through the bank transfer. Okay, do you have these documents that confirm official employment of your father in the Czech Republic? I've provided his passport documents. My father died in 2013, and his passport includes these work visas, which are showing that he was there. Okay, thank you.
So thank you very much for participating in this competition and coming to the interview. So today that's all from us, and the interview is over. So our decision will be announced on Wednesday, 1st of October, in the morning. Maybe at 10 o'clock will be our official meeting. It will be broadcasted, so you will see the results of this competition. So thank you very much, and good luck.
Closing remarks.
Yes, but maybe you have some closing remarks. We extended our time, but forgot to give you a floor for some closing comments or remarks. If you have some, please.
Thank you, everyone, for attention. Thank you again for inviting me to the interview, for listening to me, and I wish you to take proper decisions.
До побачення.
Thank you, goodbye.
Дайте кнопку.
Добрий
Good morning.
Good morning. So we have our third interview today for the position of disciplinary inspector, and we have Pan Dmitro Kriklevets. At the beginning, let me introduce our commission. From this interview, we have all commission members present. I am Reda Moliene, the chair of the commission. And the commission members are as follows: Yulia Bokova, Olena Kopi, Olha Popikova, Pavel Zelinchik, and John Ehrlich. Would you have any requests regarding the composition of the commission?
No, thank you. I trust the commission completely.
So the interview will last for about 1 hour. Sometimes we prolong 10 or 15 minutes, it depends, but in principle it's about 1 hour. And you will be asked to present your motivation, your professional background, and competences that are important for this particular position. Then we will ask some questions about your professional experiences and your some considerations about some important issues, and also some questions about regarding the integrity and property and assets. And at the end of the interview, you will have several minutes for your final comments. So the interview is broadcasted, as you probably know. So if you have any information that it falls under restrictions for its public disclosure under the martial law, please tell us, and we will take the decision accordingly regarding this information and the part of interview. So if you do not have any comments at this moment, so we could start from your presentation.
Thank you. Can you hear me?
Стосовно інформації,
Regarding the information which shall be closed, no, I don't have such information.
шановні
Regarding, so, dear commission members, my name is Dmitro Kriklevets. I'm a candidate for the position of a disciplinary inspector in the service of disciplinary inspectors under High Council of Justice. I was born back in 1989 in Mukachevo settlement, that's Zakarpattia region.
проживав
I had lived all the time in Lviv, and in 2006 I graduated from the secondary school and entered the first year of a legal department of the Lviv National University named after Ivan Franko. It means that at 2010 I received a bachelor diploma, and in 2011 I graduated from and received Master of Law. Then I worked at the prosecutor's office in different prosecutor offices in the city of Lviv. I worked as an intern, senior investigator, intern, senior assistant to a prosecutor. De facto, when I passed certification, I left prosecution services, and I started, I enrolled into the Department of Criminal Law and Criminology in Van Franco National University of Law, studying there. So I was a student of the postgraduate studies there, and at the same time I also practiced my bar activities, and I worked also at the Lviv Regional Center on provision of second legal aid. So it means that I worked as a lawyer by trade. But then I focused only on my academic field, academic work, and de facto till now, I keep working at this university. I work at the Department of Criminal Law and Criminology. So it means that first I worked there as an assistant, and now I'm associate professor of the Department of Criminal Law and Criminology. I live in Lviv. I'm married. My wife is on maternity leave right now. I have 2 children. My daughter, she's 3 years old, and my son, he's 1 year and 4 months old. So that's all. This is a general pillars of my professional career. Thank you.
Presenting your professional and some aspects of your personal life, which is very important as well. Maybe you could just, at least in a few sentences, could tell us why are you applying for this position, your motivation to be here.
Thank you. So first of all, I think that the legal profession and legal trade, you know, that's a profession which requires constant development. And nowadays, this potential opportunity to work at the role of a disciplinary inspector, and I think that that's an opportunity for me to develop. I mean here to do some practical work, because, yeah, some time passed, and I realized that science is good, and it's good to work in the academic field, but at the same time, it's great to be involved into real practice, to be a practitioner. So another thing, at this position, I see for myself an opportunity to contribute, maybe indirectly, to the judicial reform which has been lasting in Ukraine for a few years already. Specifically in terms of contributing to ensure quality of judges. So for me, this work is interesting.
So for your presentation now, we will start our session of questions and discussions, and I'm giving the floor to our commission member, Olena Kovbi, to start our session. Thank you.
Вітаю вас, пане Дмитре.
So hello, dear Dmitro. And to continue what you have said, to follow up what you have said, that you would like to contribute to the judicial reform. Tell us, please, what's your experience? What are your skills that would give you such an opportunity? And how you are going to do it as a disciplinary inspector? Thank you. Thank you for your question. To my understanding, maybe I'm wrong, but when I was preparing myself to a practical assessment, generally speaking, a job of a disciplinary inspector is somehow similar to job of an investigator. And I have such experience. During my career pathway, so I started working in the prosecutor's office as an investigator. Then I performed the role of supporting public prosecutors' work. So I think that such works have something similar in its nature, because an inspector should look for some facts, should verify it, check it. So it's interesting for me, this work, you know, this living work, because you work with facts, you work with people. Yeah, it's a complicated task, but that's vivid, dynamic work, and I like it. Thank you. And what do you mean under working with people? For example, a disciplinary inspector checks complaints, so carries out a preliminary review or verification. So as far as I understand, maybe he communicates with complainants, with one party, another party. And how does this communication take place, to your opinion? Officially. So official documents shall be sent out explanations shall be received on the demand of a disciplinary inspector. Is it written communication or real-life communication? I think it's hard to say. I think both. Maybe I'm wrong. So you think that you have a right, when you consider a disciplinary case, that you have a right for real-life communication? Maybe I'm wrong, but I thought that yes. And what is the purpose of such communication, if it happens, and how shall it be done? And what are the grounds for it? What are preconditions for it? It's hard to say. You don't know, no. Okay. Tell us, please, to your opinion, what are the key challenges which raise in front of the service of disciplinary inspectors? And if you are appointed as a disciplinary inspector, how are you going to overcome it? I think that the key challenge is to ensure impartiality or objectiveness of verification, to ensure independence during verification. And the key method how to overcome it, I think that the inspector shall be guided by law, by legislation, so it will serve also as a guarantee for their independence. And of course, at the same time, to be fair. So, as I have mentioned already before, trying to establish how it was in reality, what happened in reality. Thank you. In your motivation letter, you mentioned, among other things, that inspector's work is interesting for you because you will be able to contribute to ensure high standards of functioning of judiciary system and improving personal qualities of its staff. What did you mean here under staff, judges, and if yes, how you are going to improve personal qualities of judges? Yes, yeah, I've mentioned it. I think that indirectly, I will manage to do it, because as far as I understand, a disciplinary inspector doesn't make final decisions, but the quality of work of a disciplinary inspector impacts on consideration of disciplinary cases, disciplinary complaints. So this is the whole one system consisting of different elements, and each element shall work properly in order to achieve proper results. So you think that when you show that your work is qualitative, you will somehow impact on the work of judges? Yeah, I think that indirectly and globally speaking, then yes. Interesting opinion. So if a disciplinary authority, a disciplinary body, takes into consideration findings of disciplinary inspectors, and this is a well-known open practice, then it's such a signal that some violations could lead to disciplinary responsibility. I've got your point. Thank you. In your motivation letter, you also mentioned that salary also plays not the smallest role in this issue. Is it decisive factor for you? Not decisive, but yeah, of course, I'm not going to lie. The decent remuneration is an important factor, but not a decisive one. So if I need to choose between a high remuneration and a non-interesting job, or interesting job but lower remuneration, I would choose so interesting job rather than high remuneration. Okay, thank you. So for the last 10 years you have been working in the academic field, and you have so started working in the academic field with some practical experience. So before academic field you had worked in the prosecution authorities. Now you would like to go in reverse. So why is it so? Why you don't practice law right now? De facto, I had been working as a lawyer, as an attorney, more or less actively till 2015. And in 2015, I suspended my license to practice law. At that moment, so we are speaking about the year 2015, at that moment, I needed to choose either to enter the postgraduate studies and write a postgraduate thesis, or to work as a practitioner, so to work somewhere. So maybe someone is capable to combine two such functions, but for me it was difficult because academic work requires daily work, and it was difficult for me. Thank you, I've got your point. For you, it was quite unsuccessful attempt to take a role of a judge. It was the latest competition. You challenged it, you didn't agree with it. But as of now, what do you think about that competition? So do you think that the decision of non-admission for you to the competition of a judge was not very fair? No, I can't say that I challenged it. No, I rather asked High Qualification Commission of Judges to reconsider it. So the decision is lawful, of course, because what was the problem there? I submitted an extract from DIA app that there were no criminal convictions, and the extract was issued 27th or 25th of February, and the rules clearly stated that it should not be later than 1st of March. So from formal perspective, it was my mistake. But why you decided then to challenge such actions of a KCJ in the court? No, I didn't do it. I didn't challenge those actions in the court. No. I submitted a letter to the High Qualification Commission of Judges. I sent them a letter. I didn't challenge it in the court. Okay, if next year there is another competition for a position of a judge, and the commission today decides to appoint you as a disciplinary inspector, what would be a priority for you? A disciplinary inspector or a judge? Again, I don't want to, to lie or hide something, but from today's perspective, maybe I would like to try. I would like to try myself also in a judicial competition, in a competition for a position of a judge. But also it depends what the court is. So the specialization of a court, general jurisdiction, first instance, second instance. But that's your decision what specialization you shall choose. Yes, yeah, that depends on you. Yeah. So general jurisdiction. Okay, it's general specialization. Okay, thank you, I've got your point. Have you familiarized yourself with the rules of procedure of the HCJ? I have read some certain provisions regarding which specific provisions of the rules of procedure did you read? Those provisions related to the opening of proceedings under disciplinary complaints and regarding carrying out review of a complaint. What happens first, opening of a disciplinary proceeding or carrying out a review? So according to the provisions, according to the automized system, the complaint is assigned to a disciplinary inspector. An inspector reviews whether indeed there are preconditions to open a disciplinary proceeding. Then, based on their findings, disciplinary chamber decides whether on satisfy opening of the complaint or not, and then an inspector carries out preliminary review and prepares findings. But what if a disciplinary chamber doesn't agree with your findings and denies an opening, but you think that there are all preconditions to open a disciplinary proceeding? What will be your actions? It's hard for me to say. I think that I have no right to challenge it. So if the disciplinary chamber thinks like this, then there are preconditions for it. Do you know about such thing as a motivated demand of a disciplinary inspector? So do you mean that based on a motivated demand, if I'm not mistaken, a disciplinary inspector can raise a question or of for an HCJ in its full composition to reconsider a case. But you think that you have no right for it? No, I made a mistake. I forgot. So you have right or you have no right? It looks like that. Yeah, you have right, right. And what the period of time that you within which you can do it? I don't know. Okay, tell me, please. Okay, let's imagine you are assigned with disciplinary cases, not a one, but 100, 1,000 complaints. What are you going to do? So that's a question related to prioritization. In which situations a disciplinary case presents a priority, and what shall be focus of attention of a disciplinary inspector?
The law defines prioritization, so there are several categories of proceedings that are priority ones. That is primarily those categories of proceedings, if I'm not wrong, when disciplinary proceeding has already been opened with respect to judges, those categories where the issue on qualification assessment of judges is considered, and I think there are some other categories that are prioritized. So, if the disciplinary case was initiated, by whom? If you get, no, let's put it this way. During distribution of cases, should a disciplinary case initiated by the disciplinary chamber be distributed as well? If I understand correctly, the law says that anyone can submit a complaint. No, I'm not about that. Before creation of the service of disciplinary inspectors, there was a huge number of disciplinary cases. And once the disciplinary function of the HCJ was restored, there were disciplinary chambers working for some period of time. And disciplinary chambers were taking decisions and the member of the HCJ performed the function of the disciplinary inspector. And in many cases, disciplinary proceedings were initiated, but they were not considered before establishment of the service of disciplinary inspectors. Are these cases distributed among disciplinary inspectors? I don't remember for sure. You don't know that? No. Colleagues, I have no other questions in this block.
Julia.
Thank you. Hello, Dmitro. I have the following questions to you. As you remember, a year ago, there was established the service of disciplinary inspectors. Disciplinary inspectors were selected, and the service of disciplinary inspectors within the HCJ started its work. Have you had a chance to observe the work of service disciplinary inspectors? Or have you been following it? Now you're a candidate for the position of the inspector. Have you been following the work of the service of disciplinary inspectors during consideration of disciplinary complaints by disciplinary chambers? I know that sessions and meetings of the HCJ are broadcast, but I have not watched the broadcasts. I read what was published in the news. I know that I think since December 24th of last year, the newly established service of disciplinary inspectors started working. And I've also looked through the practice when I was preparing for the practical assignment. Okay, thank you. If you have not been following, maybe you know from the mass media, maybe you've seen some information about that. How do you assess the work of the service of disciplinary inspectors? I have no grounds for the negative assessment. I believe that the very fact previously it was published that the service in Ukraine has been established similarly to the one in Moldova. And those assessments that I've come across have all been positive. It's believed that it is good that the independent body is conducting preliminary check of complaints. So I have no grounds to give some negative assessment. Okay, thank you for your answer. Taking into account your experience of work, you have not worked in the judiciary, right? Maybe I had some internship when I was a student, but you know, it was very short term. And I was also applying for competitions, but no, I have not worked in the judiciary. Okay, so for you, this is a new position, new challenges. Which difficulties do you see for yourself in case you are appointed to the position? I think that difficulties will be, firstly, that I will have to learn probably from scratch in some instances. That's difficult, but I don't believe that this is something that that is not insurmountable. So I will have just to pay more attention to self-education. Secondly, probably there will be a big workload, and you've asked about that. It is necessary to have proper time management, to decide on priorities in work. That's difficult, but it's also possible to cope with that. Tell me, please, according to the current legislation, who should initiate the disciplinary proceeding with respect to a judge? The law sets out that anyone can do that. These can be participants of proceedings. Sometimes a complaint is submitted by representatives of different organizations. It can also happen that the disciplinary proceeding is opened upon the initiative of any of the members of the High Council of Justice. Tell me, please, which are the terms for bringing to disciplinary liability? Unfortunately, I cannot recall that. I'm afraid to make a mistake, so it's better not to answer. Okay, thank you. And let's imagine a situation that during the court hearing, a judge with disrespect treats and communicates with the parties to the proceeding. How would you qualify actions of the judge? Thank you for your question. Here, the matter is that the very notion of disrespect is quite subjective. For example, the claimant may consider it disrespect, but it may be considered as normal attitude. If there are really grounds to bring the judge to disciplinary liability, then it may be a ground. I cannot recall the article. I think it's Article 108 of the law of Ukraine on the judiciary and the status of judges, and that is about the violation of ethical requirements. Ethical requirements are regulated by the Code of Judicial Ethics adopted by the Congress of Judges, and there are also Bangalore principles as well. And there it is stated that not only in professional activities, but in any activities, a judge shall treat everyone with respect. So it is not just necessary to assess whether it was a manifestation of disrespect or no, and that is difficult. Thank you. Tell me, please, which sources of evidence would you use in the disciplinary proceeding? Here, as I have understood it for myself, the basis of the proceeding, disciplinary proceeding, in particular the one with respect to proving, is set out by the law of Ukraine on the High Council of Justice. But there it is very described in very general terms. So there is no such approach to sources of origin as we have evidence as we have that in criminal or civil process, where there are like experts' conclusions or testimonies of witnesses, etc. And the practice of the HCJ say is that the HCJ is using a broader approach to that. The evidence is assessed not in terms of being admissible or non-admissible accordingly, but the evidence is assessed in totality, and information from the evidence is assessed. These might be different explanations, these might be documents. In some instances, these are even classified information of covert investigative actions, and that is also treated as acceptable and admissible evidence. And these might be also materials of the criminal proceeding. When it is possible to use materials of covert investigative actions, when they are firstly declassified, this status of classified information shall be removed by the prosecutor, then it is possible to refer to them. And in practice, there are instances there is such a problem that judges and their representatives during disciplinary proceedings refer to the clause of the Criminal Procedure Code that stipulates that materials of covert investigative actions may be used only in the criminal proceeding where they were conducted. But I know that the High Council of Justice is approaching this matter broader. There is an alternative opinion. They refer to the law of Ukraine on operational and investigative activities, and there is such a provision there that, which allows using these materials in other instances as well. Thank you. That's it from my side. Good afternoon. Good afternoon. At first, I would like to make a comment. While studying your motivation letter, I paid attention to the phrase that I remember very well, regarding the fact that your professional qualities include the love for legal sciences as the key one. Not often you can find such expression of love for the jurisprudence, and that's what I wanted to share. And now about questions. You are a candidate of legal sciences, right? You? Tell me, please. What is your attitude towards academic integrity? Because recently it has been becoming more and more topical. Thank you. My attitude is very principled. So, academic integrity. Quite often, for some reason, it is considered only from the perspective of an academician borrowing someone's work, but as a lecturer, I understand this notion in a broader sense. It concerns all the participants of the educational process. And even, for example, when the student during exam is cheating, that's also one of the violations of academic integrity principles. And I respond to these instances in a principled manner. We have the code of academic integrity in our university. We have different violations with specified consequences, for example, cancellation of the student's work, etc. So I do not ignore these facts. And I also do not violate the principles of academic integrity. And I believe that borrowing someone's publication without a reference and to publish it as your own paper is the same as going to a store and stealing something there. It's the same theft, but for some reason, quite often people are just ignoring that. In your opinion, can the issue of academic dishonesty be a ground for the disciplinary responsibility of a judge? You know, I have not thought about that. If we take such instances that happen abroad, when top officials are retiring, then yes, I think that there are grounds for that, because it cannot happen that, for example, a person in the academic sphere is dishonest, and in all the other spheres of life, there's, for example, in judicial work, that this person is completely honest. No. If the person is violating, for example, rules in one sphere, then it is highly probable that, if necessary, the person will violate rules in other spheres. Maybe my colleagues will correct me, but I think we do not have cases on academic dishonesty as a ground for disciplinary liability yet. Okay, my last question to you. In your opinion, why do we have so many disciplinary cases regarding investigative judges? Indeed, right now, those cases that we are considering now, disciplinary cases, concern a large number of investigative judges in particular. Investigative judge, I've studied that topic once. The investigative judge actually decides on issues that are global, principled for a criminal process. And as always, that's a dispute. And always in a dispute, regardless of the decision obtained, there will be a party that will be not satisfied with that decision. I mean that the existence of the complaint with respect to investigative judge does not mean automatically that the judge violated the law. Maybe some of them are justified, maybe some of them have some hidden motives, that maybe it's like pressure on judge or retaliation against the judge. So I think that there are different motivations for that. Maybe it's because the investigative judges consider cases with respect to persons, especially when we are talking about fundamental rights, human rights, like the right for freedom, right for protection. Maybe that's mostly the reason for that, apart from what you've mentioned. That's also the case, like a limitation of freedom, liberty, property, yes. And these are interim measures and different complaints. That's really the matter that is quite sensitive, as people are saying now. But my opinion is that a large number of complaints does not mean that the investigative judges really break the law in a large scale. No, we are not making this conclusion. No, we are just stating that we have a large number of such cases. Thank you.
Thank you. You had an experience in your professional life as an investigator, assistant prosecutor. So could you please tell us the most difficult situations for you as a professional and as a person while being in these positions and dealing with these cases? What were the most difficult?
Thank you. Well, the work was quite difficult. First of all, we are talking about a large scope of work, many proceedings. I also had old proceedings, for example, since mid-90s, which have been investigated. Proceedings were suspended. Back then, these were the cases on murders. These are the cases that are difficult as such. And overall, for the former graduate, given that at first I was the intern, so internship is basically as a test, but that's quite difficult to deal with that. It's a completely different environment, as for example, compared to in the university we have the academic atmosphere. But when you are conducting a pretrial investigation, you are facing the life in not very pleasant manifestations of life, and that's quite difficult. You have to get used to that, and you need time for that, and that was difficult. And also a large scope of work. That was also difficult. So I had to work on the proceedings that are promising, as well as regarding proceedings which have basically no promising outcome, but they were not closed, so I had to continue working under them.
Aspects that you mention and emphasize, this emotional aspect of your work, and also that you dealt with sensitive situations where you have to decide upon the main rights and basic and rights of a person. And sometimes people in this kind of situations, critical situations, they understand that they can be derived from their liberty, etc. They become very, radical in some of their solutions, and then they try to solve their situation in not always legal measures and sometimes very radical measures. Have you ever experienced some not only pressure but maybe threats from those persons that were under investigation, or some other persons that they wanted to be involved and somehow to impact your decisions or your solutions? So could you please tell us if you had this kind of situation?
Thank you. No, I didn't have such experience of so direct and clear pressure or threats, but sometimes happens such emotional response, emotional reaction. For example, there is an arrested person and the attorney, the defense lawyer comes, and sometimes they overcross this line. And so they could say that you are acting illegally, we are going to complain against you. But I can't consider that it's like a pressure. No. If there is a procedural opportunity, they have a right to challenge, but there were no such threats.
So as a disciplinary inspector, if you would be appointed to this position, you would have to present your opinion, to discuss. So would you consider communication skills important for this position as one of the major skills that the inspector has to possess?
I think that, no, I can't say that the major, but one of the major skills. I think that in current world, it's not enough to be a good professional. You need to know how to build this bridge, build this rapport. You need to know how to communicate, how to express your opinion for everyone hear you, and for you to hear everyone.
Would you think that you have good communication abilities and skills? You have like well-developed skills in this area?
I think that yes. De facto, since 2014, when I studied in the postgraduate courses, I started providing lectures, then started being a lecturer. And being a lecturer, it's about communication with students, with fellow lecturers. I also worked as an attorney, as a defense lawyer in criminal proceedings. I also had so many opportunities to participate in different court hearings. At that moment, remote court hearings were not that much popular. So everything happened in courts, sessions, in courtrooms, or in university rooms. So I think that I'm quite good in it. There were no complaints against me from the side of students. I tried to treat them with respect, and I think that's a key to right communication.
To my colleagues, because I see that we've got some 17 minutes for interview. So John, please, the floor is yours.
Добрий день.
Good afternoon. Good afternoon.
I am very curious about your master's thesis or doctoral thesis implementation of the principle of adversarial proceedings during the consideration of complaints by an investigating judge. Can you very briefly synopsize what your thesis was about?
Yeah, thank you. Thank you for your question.
По суті, якщо
So, generally speaking,
таке ключове
if
наукове завдання,
it would just give you the key thing. So it was to identify how the activities of an investigating judge regarding the lack of actions from the side of an investigator, prosecutor, indeed increases the principle of contestability, of adversarial principle. In general, of course, there could be no complete adversariality in this world.
And could you just explain that a little bit more, that the complaints increase? What were the complaints?
раніше
So before,
коли
de facto,
діяв
when
кримінальний
the
процесуальний
previous criminal procedure code was in force, there was no such a term as an investigating judge. Of course, there was judicial control performed, but usually complaints against actions or failure to act from the side of judges were considered by prosecutors or heads of pre-trial investigation bodies. But when the current criminal procedural code became in force, one of the key achievements which was declared there as entered into the provisions, that indeed it will ensure adversariality of the process. It will not only the prosecutor will dominate, but also the defense side will have its leverages on the of impact on the process. And one of the aspects was considered that there is a specific section in the criminal procedural code of Ukraine which covers certain actions or lack of actions of an investigating judge or prosecutor, and they could be challenged in a court. And that means that such complaints shall not be decided by a prosecutor, but by an investigating judge who is not interested in results of proceeding. For example, it could be a denial to open a criminal case, a denial to give a status of a victim to a person, or a denial to carry out some kind of investigative measures, etc.
Thank you.
Дякую вам.
Can you tell me how familiar are you with the judicial ethics in Ukraine?
коли я готувався до
When I was preparing myself to the competition in appellate courts and to the stage of practical assignments, I read through two normative acts. These are specialized secondary legislation, these Bangalore principles, and correspondingly Code of Judicial Ethics, which was adopted by the Congress of Judges of Ukraine.
я
So yeah, I know the provisions of these two documents.
And do you have any experience in investigating judicial ethics at all?
тобто безпосередньо особисто
I don't have some direct experience, personal experience. When I worked as a prosecutor or as a defense lawyer, I was lucky. There were no such preconditions even to think about submitting a disciplinary complaint. That's why I know about this topic only from the case law of the HCJ and the law, but I don't have personal experience.
You mentioned that you want to contribute to judicial reform and ensure the quality of judges. In your opinion, what defines the quality of judges?
я думаю, що якість
I think that the quality of judges You know, it's quite an subjective issue, quite a wide issue. It's not, the quality is not only about professionalism of a judge to consider cases. The quality covers also communicative skills of a judge. For example, right now there are ongoing competitions for positions of judges, and one of the assessment criteria is their communicative skills of candidates. So it means that a judge shall be an exemplary model, not only as a professional but also as a human being, not only within the process but also beyond the process. So I think that a judge in particular, and if a person agreed to be a judge, so whether they want it or not, but they voluntarily take on themselves some obligations. So they are under constant attention, because what I mean here is that the society, the public, will always have some high expectations towards such professionals, and you shall meet such expectations.
Can you be a little more specific about what those expectations are?
Do you mean from the side of the public, from the society?
From society, from public, yeah.
I think that the society demands, first of all, and indeed, it should be like this. A judge shall be professional. What I mean here, they shall know legislation, case law, not only national but also international. A judge shall respect rights of parties to the process, rights of other people. It means that a judge shall treat other people with respect. So the third thing, a judge shall be fair and shall act according to legislation and know how to justify their opinion.
Do you think the lack of respect by a judge should be grounds for discipline? And if so, why?
The issue of respect, the notion of respect, again, it's quite a subjective notion. So when we are speaking about disciplinary responsibility, we need to assess specific facts. What was violated specifically by a judge, how a judge treated this or that participant to the protest, or what were the other actions committed by a judge. Then we can make some conclusions. For example, when there was a practical assignment which we performed, there were clear details given to us, and based on those details, we were able to make some conclusions. But judges are also human beings, and if a judge is harsh by character, by nature, someone could, perceive it as lack of respect. But in reality, it goes within the limits of acceptable. So this borderline is so thin. You need to go into details, into facts, and then you can make a conclusion whether indeed it was a disciplinary offense or not.
And where's the borderline? Where's the borderline of disrespect that is not subject to discipline, and when the judge crosses over that borderline and should be subjected to discipline? How do you make that determination?
So that's a good question. Actually, neither in Bangalore principles nor in Code of Ethics such borderline is defined. So yes, there are general terms regarding behavior of judges. I think that somehow of generally defined understanding, perception, or some regarding moral standards of how different persons shall communicate between each other, interact between each other. It's hard. It's impossible to define very clearly.
How would you define it?
I would define, applying such a short formula maybe. what is a good attitude or treatment? When person treats others as they want that other people treat them. So it means that I don't think that any judge or any civil servant wants that they are shouted at or insulted with some obscene words. So I think that this could be an approach.
I see we are short on time, so thank you for your answers. I'll turn it over to my colleague.
Дякую вам.
Будь ласка.
Thank you. Good morning. I will start with this question. It's very technical. Did you have a chance to watch or listen to the interviews from your colleagues from this morning or not?
No.
Сьогодні, на жаль,
No, unfortunately, I didn't have an opportunity to watch interviews that took place today. In the morning I arrived, and there was some work which I needed to do remotely.
Thank you. It was just to make sure I will give everyone equal opportunities to respond to my questions. So, my first question relates to your motivation letter, where you mentioned, in my opinion, the main challenges in the work of disciplinary inspector are related to the risk of losing independence and transparency in work. Can you elaborate more how that can happen? How the risk can be materialized in real world? What can happen to independence, and how can inspector somehow lose the adherence to principles of transparency? Be more specific about this. Thanks.
Так, дякую.
Yes, thank you.
один з можливих,
As an example, as in one possible option,
що, наприклад, дисциплінарний
for example, a disciplinary inspector
емоційно сприймає свою,
is quite emotional and treating their job. So it means that an inspector stops acting impartially. And here, that's a high threat for impartiality, high risk to lose impartiality. For example, he starts feeling some empathy, human empathy towards a complainant. Or, for example, he starts pitying a judge who is under complaint. So from one side, they see that yes, preconditions for this disciplinary complaint. From the other side, they start pitying this judge. So such, controversial feelings. That's a risk. And
потрібно прагнути
you need to strive for being fair and being impartial, to leave your feelings behind.
Okay, so that was about independence and transparency.
щодо прозорості.
Regarding transparency,
Не потрібно дисциплінарний інспектор
a
повинен
disciplinary inspector shall work in such a way that when you read their findings, you have no issues, no concerns regarding their real motives. All their motives shall be based exclusively on what they investigated, what they reviewed. Only then their findings, their decision will be transparent and understandable.
Can it happen in real life that the disciplinary inspector will find himself or herself under some kind of pressure to not to go into certain disciplinary proceedings, or on the other side to go even if the grounds are not weak? Can you imagine that this can happen in countries like Slovakia, Ukraine, other Central European and Eastern European countries which lack the long tradition of independent judiciary?
Дякую вам.
Thank you. I think that it doesn't depend on a specific geographical location of a country. That's not about traditions actually. I think in any
певний, скажімо,
state,
державний службовець
a judge or a civil servant who makes certain decisions could find themselves in such a situation. For example, I'm a disciplinary inspector. I'm assigned with a complaint against a judge who is my relative. And just a simple example, it's already conflict of interest. And it means, that there are relevant mechanisms on how to handle this issue.
Very much. much for your answer. I will follow up very briefly on this one. The pressure can have a form of a direct attempt to influence the inspector or a judge to deliver certain type of verdict, or it can be indirect, when the expectations from those who try to influence the judge or inspector are clear, the inspector or judge are aware of those expectations. They know also that if they don't follow that expectation, if they don't fulfill it, it may have some consequences about their relationships and so on. Which one of these two, direct or indirect, is, in your view, is more difficult to handle?
I think that the second indirect is more difficult, because the direct one, you know, you have specific proposals, you can refuse them, you can take other actions according to legislation on corruption prevention if we're speaking about some kind of corruptional pressure. And indirect is harder to fight against. What, for example, you mentioned regarding expectations from the society, and the disciplinary inspector cannot change expectations of the society. And you know, maybe it's possible, but you need a lot of time to do it. So I think that it's harder to deal with it.
Okay, thank you. My last question will follow up on the question raised by my colleague John. He already asked you about the qualities of the judge. What defines the quality of the judge? In the recent history of Ukraine, taking into account, let's say, last 15 years, can you name some situations or types of behavior where judges in Ukraine betrayed these ideals of lawfulness, impartiality, fairness? If the first question is whether you are aware of such cases. Of course, we don't speak about names and situations. I am interested to hear about types. And what are, in your view, the most severe, most serious deviations from fulfilling the judge's role?
Thank you for your question. In my personal practice, luckily, I have not encountered this. But if we are talking in general, then these instances happen. I know about them. For example, even when I was preparing for the practical exam, I think there were about 8 examples, different decisions of the High Council of Justice, where they describe these facts. For example, when it was about demanding unlawful benefit by a judge, other facts, they are established in these decisions. So it happens that this is a fact. In this regard, they exist.
From the types of deviation or violations, you mentioned unlawful benefits. Is this all, or you may name some other types of violations?
These might be such violations as, firstly, if the judge is subject to some corruption influence, there were decisions about that as well. It might also happen that we are not talking about corruption, but for example, when a judge, that's also one of the problems, when the judge is fulfilling professional duties improperly. That's also can be a problem. But the problem here is that this is a very fine line. Quite often complaints are submitted with respect to the fact that the judge resolved the case incorrectly. Here we need to have this clear distinguishment.
In this part, it's all, and I think we will move to the second part, Madam Chair. We will move to the second part. Maybe I will have then some questions. Thank you.
We will have some questions regarding your financial integrity, assets and income, and etc. So, please.
Yes, Dmytro, I have one question to you about your financial integrity, but it will be quite extensive. You own many assets, in particular 2 apartments in Lviv with the area of 165 and 50 square meters. 50 square meters, that is a store apartment. Then you own a garage, cars, and you've explained it by saying that all of that was funded by your parents and grandfather. At the same time, is that correct? All the property was bought by you at the expense of your parents and grandfather. Yes, yes. With respect to each of the assets, I've provided explanations. That's correct. But in your explanations, you have provided title documents, but you have not provided any documents to confirm that your parents and grandparents had this opportunity. Can you explain why you did not provide these documents, and how can you confirm that your parents and grandfathers had this financial opportunity? With respect to why I did not provide documents, because in the list of questions, basically, there was a very general wording, provide title documents. And that's why I've provided scanned copies of different experts and documents with respect to each of the objects. So, with respect to the financial situation of both grandfathers, there were no questions worded in such a way. But you could imagine, you've watched previous interviews, you could imagine that such a question would be asked to you because you have property. You are referring to the fact that you did not have income and funds that would allow you to buy all of that property, and you are saying that all of that was bought using funds of other persons. And at the same time, you are not providing any confirmation of their financial capacities, especially given that your father and grandfather, if I'm not mistaken, one of the grandfathers, worked in prosecutors' offices. And where did your mom and other grandfather work? Another grandfather worked in the commerce sector. His last place of work was at the position of the director. That was joint Ukrainian-American enterprise that was called IBB Barba LLC. He was the director of that enterprise. He was responsible for one of the directions. His direction was production of meat products. They were also engaged in mineral waters, and they were also dealing with mineral fertilizers. That's about that. And he worked until 2011, so until he reached the age of 70. And he also had real estate objects, 1, 2 houses. So he was selling all of that, and he was dividing that among his grandchildren, including me. And what was the principle according to which this property was divided? Because all of the property is owned by you, but for some reason your brother is using it. How can you explain that? No, I mean that my grandfather was giving funds. There are 3 of us, that is my brother and my cousin and me. And he was always dividing all of that in equal parts among the 3 of us. He was giving funds. And the apartment that you are asking about, that yes, it is used by my brother. He does not live there, but my brother works in the IT sphere. He's a software developer, so he's using that apartment basically as his office. That is the store apartment. No, the apartment that you with the area of 51 square meters. And what about the store apartment? It is used by another co-owner. There are 2 co-owners. I have 50%, another person has 50%. And who is that other co-owner? Karelin Ivan Olegovich. So he has 50%. And what is your relationship with him? Friend. Your friend, yes. And the apartment was bought by your grandfather. No, the store apartment was bought by parents in my part, in my share. So my parents funded the purchase of 50% of that apartment. And the apartment where I live, the first in your list of questions, that was the help of my grandfather's. The situation is quite strange because this store apartment was bought by your parents. And as far as I understand, your friend did not invest into that. That apartment was registered in your name. You are the owner. Your friend is using that in order to get revenues while you are not getting any revenues. Is that correct? And what is the point? No, not like that. According to documents, he's the co-owner. So if we are talking about the store apartment, I own 50% of that, and he owns 50% of that. So that was just like an ordinary apartment. Why am I not getting income from that? Because major repair works and reconstruction were conducted completely by him using his own funds. So when we bought it, it was in a very poor condition. What is the point of buying even 50% of this apartment by your parents and registering it in your name? That was the idea back in 2013, that maybe we will organize an office there, and accordingly we will use it, some part of that for legal practice, because my father has the attorney's license, and my mom has, and I have, and my deceased grandmom had a licensed attorney. And he could use the other part. There are two separate entrances, and he is a doctor, and he is having could use some private practice. You've mentioned your mother has the attorney's license. Has she worked as an attorney during her entire lifetime, or what was she doing before getting the attorney's license? So actually she immediately after graduation from Lviv University in 1988, if I'm not mistaken, she was immediately sent to the bar. I think until about 1995 or 1996, she was engaged in attorney's activities. Then she worked at the positions of the legal consultant in the bank. That was Bank Ukraine. It does not exist anymore. And she worked in its main office in Lviv until 2000. Okay, all of that is good, but how can you confirm that your parents and grandfathers had these funds in order to buy all of that property? How can you refute our doubts that they really had enough funds? And in follow-up, I have a question about your savings. As far as I understand, they also were accumulated at the expense of getting money from your parents and grandfather. Yes, partially. I've mentioned in my explanations, in 2021 we had a wedding, so savings include wedding gifts. These savings also include my wife's savings, which she earned. Where did she earn them? She worked at different positions. She worked as financial business analyst until July of 2022 in different institutions. That is Hal Naftogaz concern in Lviv. Her last place of work is LLC Solomia Service. Yes. That is a network of pharmacies, Podorozhnik. So can you provide documents to us? As of today, as of right now, I do not have these documents, but I can find them. Okay, my last question is, as you said, your wife used to work at Solomia Service, and she received some social benefits from this enterprise. What were these social benefits? These are the benefits that she received during the maternity leave. So she went on maternity leave from that position. So for each child on a monthly basis, she is not getting any social benefits for the daughter because that was until the age of 3, but she is still getting them for the son. Okay, I have no more questions.
have question? For maybe one question or so.
Okay.
If you do not object, we would like.
Звичайно.
Yes, of course.
Brief, but I find this interesting also for our understanding and for further deliberations on similar issues. I'm thinking about the fact, which reminds me of my own country, Slovakia in 2013 or 14. It was in a situation when the judges who came in the system during the selection processes were in more than 50% family members of those who were already in the system, in Ministry of Justice, in Judicial Council, in the courts. So this created a very big debate about the family relations of lawyers. Now, you mentioned that you are also from a very strong legal family, which has its great benefits because the kids are exposed to the legal thinking, they can benefit from the knowledge of the parents. On the other side, people in my country, and I believe also here, may be suspicious whether the family ties may or may not influence the operation of individual members if they have some family discussions and so on. How would you ensure that the people outside can trust that there is nothing going on behind the family wheel, which would have impact on any action of the family member? Thank you.
Yes, thank you. So if I understand it correctly, so how to make sure that external members of my family do not know about some specific cases, right? In this context.
There is no inappropriate influence if, for example, one family member has some interest in a specific case or a person or a matter. And of course, in family, people talk. That's natural. How would you think about ensuring that people outside will trust that nothing like that had influenced, for example, but I mean it as a general question, anyone's action in his or her profession?
Yes, thank you. Now I understand your question better. You've pointed out correctly, I'm coming from the family of lawyers. And even my great-grandfather was a lawyer, so that's the fourth generation of lawyers represented by me. I think that these manifestations that you've mentioned cannot happen because, for example, my grandfather unfortunately is the 10th year since he died. My grandmother has not practiced law since 2017. She used to be a lawyer, we used to work together, but unfortunately nowadays she is no longer with us. My mom has not worked since early 2000s. My father has not worked for 10 or 11 years either, so there are no overlapping points for us. Other family members, relatives who are lawyers or who work in some law enforcement bodies are also not there. I don't have any like that. So basically, if we, for example, talk specifically about my family, then my wife is not a lawyer either. She is a mathematician by education. So we are like, we cannot even discuss professional matters.
Thank you. So our interview is coming to the final stage. So now you have an opportunity to say some final remarks or comments if you would like to do so. So the floor is yours.
Thank you. I would like to express my gratitude for the interview. That's a really interesting experience for me. This is the first time for me being at this interview of this level and of this scale. And basically, this is my first time when I'm taking part in the interview. Thank you for organizing it. Thank you for your questions. Some of the questions even make me to have a new perspective on the role of the judge, on ethical principles. That's really useful experience. Thank you. Thank you.
Our decision will be made on the winners of the competition on Wednesday, 1st of October in the morning, and this official meeting where we'll be voting for the winners will be broadcasted. So thank you very much for coming, for preparation for this interview, and we wish you good luck. Thank you.
Дякую вам.
Thank you. Goodbye.
Good afternoon.
So we are proceeding further with our interviews with candidates for the position of the disciplinary inspector. And we have Anna Alexandra Lozniana. And we will start from the presentation of our commission. Today the commission is in its entire composition. I am Reda Molene, the chair of the commission, and we have commission members Yulia Bokova, Olena Kovbi, Olha Popikova, Paul Zelinchik, and John Erlich. Would you have any requests regarding the composition of the commission?
No, I don't have any, thank you.
So the interview will last for 1 hour or maybe a bit more. Sometimes we prolong for 10 minutes or so, but in principle it's 1 hour, and we will give you a floor to present your motivation and your professional experience and qualifications that give you the chance to participate in this competition. Then we will ask the questions about your professional experiences and according to your profile, and also some questions regarding property and financial assets. And then at the end of the interview, you will have several minutes for your final comments. I would like to notify you that the interview is broadcasted, and if you have any information which falls under restrictions for its public disclosure, according to the martial law, please give us this information, and we will make our decision regarding its disclosure. So if you do not have any requests or questions so far, so we could start from your presentation. The floor is yours, Anna Alexandra.
Дякую.
Thank you.
Доброго дня ще раз.
Good afternoon, dear colleagues, dear Commission. I'm happy to be at this stage of the selection procedure for the position of a disciplinary inspector. My name is Alexander Sergeyevich Loznian. I started my working activities in the judiciary authorities and as a court session secretary in the Court of First Instance. So I have passed through all the elements of the judiciary system, and I worked in the Kyiv Court of Appeal, in the High Specialized Court of Ukraine, and in the Supreme Court. Now I work as a chief specialist in the Office of the Prosecutor General. During my working activities in the judiciary authorities, I worked directly with judges. During almost all my period of work in the judiciary authorities. That's why I know quite well this procedure of consideration of cases regarding behavior of a judge, compliance with ethical norms, and generally what it's about. I also have, not rather have, but I'm familiar with work of the Office of Prosecutor General, specifically how the cases are considered, how the evidences are being collected, because within some of my duties, we can make some conclusions regarding the OSINT investigations, and that's why I'm a little bit familiar with such procedures. And this set of knowledge, which I have received during my work, this set of skills, I think it's enough for me to participate in the competition, maybe further to be appointed as a disciplinary inspector.
For you, thank you. So you presented your professional experience and knowledge and skills that you gained during your professional career, as allowing to apply for this position. Could you please shortly describe your motivation? Why you are applying? Why do you think this is the position that you would be dedicated to be?
You know,
дисциплінарний інспектор,
a
вона
position of a disciplinary inspector
багато
is plays a significant role
в дисциплінарному провадженні.
in a disciplinary proceeding because at this stage
Дисциплінарна
the whole disciplinary case is being formed if it's opened,
тобто
not later.
на цих на за допомогою, не за допомогою, на функції
So,
інспектора,
as
тобто які він докази буде
functions of inspector impact on it, how they're going to collect evidence, how they're going to treat it with legal assessment. It will impact on the findings which will be further submitted to consideration of the disciplinary chamber, and then it will lead to a decision of the disciplinary chamber of the HCJ if it's going to be considered as a plenary session. That's why
Я працював в
I
судовій системі, да, це
I worked inside the judiciary system, so as a consultant of the court. There, it was the same. There was a preliminary consideration of a cassation complaint, whether there are any preconditions to open a case, to dismiss a case, what procedural provisions for it, which allowed us to draft a decision on dismissal of case on the stage of the preliminary review of this case. So during this work, all these criteria were taken into account, and this criteria which shall be reviewed. So it motivates me to contribute at least a little bit, as minimum, into the work of disciplinary inspectors, because they play a significant role within the criminal case, within the disciplinary case. Sorry.
We have your motivation letter as well, but for those who are listening and watching our interview, it's also important to understand your motivation. Now I would like to start this session of questions and discussions, and I will give the floor to our commission member, Olena Kovbi, to start questions.
Вітаю вас, пане Олександре.
Greetings, Alexander. So please tell us 3 points of your motivation, 3 items of your motivation to have this position.
це в першу чергу це робити
So first of all,
вклад.
that's to
Люди своїм досвідом просто
contribute, to share my experience in considering disciplinary proceedings, because I think that each person has some periods of time during which they develop themselves and they reach the point of realizing that they could be useful in some other areas of life. For example, a person could work as a court session secretary. They gain some skills. They would like to become an assistant. And the same regarding me. I have the skills and I would like to be useful there. And what's your experience that you have already gained that could help you at your work if you are appointed as a disciplinary inspector? Because you have worked as a court session secretary and as a consultant. How much did you work as a consultant? For 4 years. Okay, so 4 years. And now you work at the position of a chief specialist. What are your duties? What do you do there at this role? And what were your duties, your functions as a consultant at the Supreme Court? And what are your duties now? And what experience at those roles of a court session secretary, consultant, and chief specialist in the office of the Prosecutor General will be useful to you at your future work as a disciplinary inspector if you are appointed to this at this role? So when I worked as a consultant at the Supreme Court, so that's the key area was our work was to work with the cassation complaints. So when you say we, what do you mean here we? I mean consultants in general. No, I'm not speaking in general. I'm speaking about your specific duties. What did you do at those roles? So, when I worked as a consultant in the Supreme Court, and generally a consultant's role, and was focused on working with cassation complaints. We worked with Chancellery or with the Secretariat of the Court. We reviewed documents and made a decision regarding opening or dismissing of case. So that's where you who made a decision. No, we were preliminary discussing it with the judge. I can't do it independently. No, you're expressing your thoughts very strangely. So you said that you made a preliminary decision. No. I mean a preliminary draft document, draft decision. No. Make a decision and draft a decision, the text of decisions. These are different things. Specifically, in which cases, regarding which cases, in which chamber. So it was civil chamber. So you worked on civil cases, and there you prepared some draft decisions. Did you prepare draft rulings or also draft decisions? Also draft resolutions. And what about now? What are your duties now? What are your duties now at this role? At the Office of the Prosecutor General, that's the analytical department. That's analytical support department. So we collect information, we maintain this information. What this information is about? Office of the Prosecutor General receives so many different types of information. This information is about the status of affairs with the criminal proceedings. So statistical data on certain criminal proceedings. So you are more focused on statistical work. Yes. Yeah, I can say so. So that's about statistical data on activities of other prosecutors' offices. Not only, it's also regarding the Office of Prosecutor General. And what about analytical part? So is it analytical and statistical activities that what you do? Because, analytical activities are different. No. That's analytical and statistical.
І крім цього, ми так само
And
наш відділ
our unit, where I directly work, also deals with OSINT investigations from the open data sources. So, when we receive some tasks to do, and we do some investigations and make certain conclusions. Investigations, or are you processing information from open sources? We call it OSINT investigations from the open source data. Okay, thank you. I've got your point. In your presentation, you mentioned that you're going to collect evidences in proper manner, that evidence shall be collected. Develop on it, please. How are you going to do it? And what specific types of evidences you are going to collect during consideration of complaint? So those evidences related directly to disciplinary proceeding, related directly or indirectly. Can you please give us more details? So are you going to send some requests, and if yes, to whom or what? Of course. So if there is a need to do so within the disciplinary proceeding, and yes, that's a prerogative function of a disciplinary inspector to send such requests on information. Just to give you a simple example, a judge committed an offense, and for example, he violated Article 130, specifically drunk driving of a vehicle. And that means that I am going to send a request to receive recording from the body camera of the police officer. So let's be specific. You receive a disciplinary complaint against a judge who was pulled over and identified that he was driving being drunk. Okay, let's assume it. Then there is a decision of the court which confirms and the judge is brought to administrative responsibility. And there is another situation when there is no decision of a court, or there is a decision of a court that this judge was not drunk. So what will be your actions? Whom you are going to send requests, and what will be those requests?
As far as I know, for example, if we take about this example, there is the case law of the Supreme Court that even disciplinary proceedings can be considered separately from criminal proceedings. That's not criminal, that's administrative responsibility. So accordingly, if that happens within the framework of one proceeding, then the decision, the ruling of the court on bringing the person will be taken into account. Where will you send requests? You have just complained, and that's it. You have nothing else. You have no rulings, nothing. What are your actions? For example, tomorrow you receive this disciplinary complaint. What are your actions? Well, we will send a request. Who we? I, inspector. I will send a request to the court to request this administrative case. And if did not happen? But you said there was a ruling. Maybe there is no ruling. I want to find out about your primary actions. You do not know whether there is a court decision or no. What will you do first? To which court will you send this request? You have no information like that. Which court will you send the request to then regarding this administrative case? That can, well, to the territorial court at the place of committal of the administrative offense, because that's the jurisdiction decided. You will send a request. What will you ask the court to do? To provide information for the study of the respective fact. And where else will you send a request? To national police bodies as well, for provision of respective materials about this offense for the study. Where else? Will you ask the judge to provide explanations? Of course, that's primarily. Of course. Will you determine whether there are witnesses or no as well? That's directly stipulated by the law. That explanations are taken. Okay, you've received all responses to your request. What are your actions then? Based on those documents, if they are sufficient, then the respective opinion is prepared. What will be your opinion about? If they are sufficient to confirm the offense, then accordingly on bringing the person to disciplinary responsibility, immediately on bringing to disciplinary responsibility, that will be your opinion. So you've collected all the evidence, and the first document that you are preparing to submit for the disciplinary chamber? No, we're talking about the stage when the proceeding is already open. I did not say that the proceeding is open. I said that you just received the document and what your actions would be. Okay, so if we will see whether it complies with requirements of the law, whether there is the corpus delicti of the disciplinary offense, then we will address who we, inspector, I will address the disciplinary chamber in order to resolve the issue on either opening or returning. Which document will you use to address the disciplinary chamber? What are you submitting to the disciplinary chamber to resolve whether there are grounds or no? What will be the document? Ruling? Rulings are prepared by the disciplinary inspector? No, not ruling. Opinion, correct. Have you already sent requests, or will you send requests after That information, this evidence is collected after opening of the disciplinary case. And what if you don't have enough materials in order to establish whether there are signs and grounds for opening the case or no? Will you send requests anywhere or no? Will you take explanations from the judge or no? Or can that be done only after opening of the proceeding? No, it can be collected. Explanations about these signs. Before opening of the disciplinary proceeding. Okay, you prepare the opinion, you see signs, you submit to the disciplinary chamber. The disciplinary chamber studies your opinion and sends it to you for improvement with some comments. If you disagree with those comments, what are you going to do? First of all, I have 10 days to correct them and to resubmit it to the disciplinary chamber. And what if you disagree with these comments and remarks expressed by the disciplinary chamber? The legislation does not envision such a function of disagreeing. If it is returned first time, I cannot recall something that the inspector cannot disagree. If you see all the signs that the judge violated and there are all the grounds for opening the disciplinary proceeding and the disciplinary proceeding refuses to open that, what are your actions? It is submitted for consideration by the plenary composition of the HCJ. How? Based on, you don't remember that. Use your own words. Who is transferring it? A member, the rapporteur of the HCJ. So if I disagree with your opinion, the chamber has taken a decision on denial in opening, and the chamber is submitting it. Who is doing that? You did this. No, the disciplinary inspector is challenging that and has the same functions. And what is the name of this document? Do you remember that? No. What is motivated request? How many days do you have? You don't remember that? No, I cannot recall it. I have no more questions now. I have questions, but I will allow my colleagues to ask questions as well. Yes, thank you.
Lord Pavel Žilinček to continue.
Thank you very much. Good morning, good afternoon. I read your motivation letter, and in one paragraph you named the main challenges of the work of disciplinary inspector, and there is quite an extensive list of challenges which I would like to discuss with you. Inspectors may face challenges in ensuring impartiality and objectivity, in particular pressure from interested parties in public cases, attempts to influence the course of the proceedings, and then there are more legal challenges, for example, distinguishing between disciplinary misconduct and judicial error, and the last is consequences of decision made. Can you tell us how would you handle a situation where one of those challenges would happen to you as an inspector? For example, somebody would try to influence your actions to start or not to start the proceedings, disciplinary proceedings against a certain judge. What would be your thoughts? What would you do if this situation happened?
Ну,
Well, first of all, how are they going to try to influence me? That plays a key role. How are they going to influence? In what manner?
there are two ways to do it. One is direct, that somebody comes and expresses his great wish that you consider in this particular case certain circumstances which aren't necessarily reflected in the documents, but he knows that it should be decided this way, and you know that this person who is trying to make this influence may be unhappy if you do something else than he or she wishes. So either it is expressed directly, or it can be also only implied that you understand that this is expected, this action of yours. You also know that if you don't follow that expectation, it may have some negative consequences, some relationship will be damaged, maybe it will even endanger your career if you don't follow that type of influence. So directly or indirectly, you can pick whichever and try to describe what would you do if this situation happened. And it can come from colleagues, from the leadership of the disciplinary service, it can come from the High Council of Justice, it can come from some powerful figures in the judiciary. This happens in various countries in various forms, but the nature is very similar everywhere. So I am trying to understand, how would you react? What would you do if this happened?
Let's start from saying that, as you've mentioned, direct influence, like from colleagues, deputy head, or member of the HCJ, there is a clear regulation that in this case the disciplinary inspector has to prepare the official note and to report on that. If that happens during the consideration of the case, that should be reported to the member of the HCJ head and deputy head of the SDI. And accordingly, the inspector has to submit a statement on interference with his activities, because activities of disciplinary inspectors are independent. Besides, it is known that this position of the disciplinary inspector has to comply with the criteria of integrity and judicial ethics. That's why these principles of integrity and judicial ethics directly stipulate that the judge has to remain impartial and objective with respect to consideration of the case. So that's why if this interference happens from some side, there is a clear mechanism stipulated for that regarding notification about that and the way of responding to that.
Thank you very much. My second question is more conceptual, and I would like to start with a technical question. Did you have a chance to listen to the interviews from with your colleagues from this morning, or you didn't watch or listen to those? No.
Well, let's be objective. I had a chance to see some like small parts, because it's time to get here.
Okay, so from today, right?
Yes, yes.
Okay, very good. Thank you for your honest reply, because that's very important for equal playground for everybody. In this case, I would like to ask a question. If there is a case where it is necessary, I will actually use the sentence from your motivation letter, distinguishing between disciplinary misconduct and judicial error. How to you listed this among the challenges of inspectors, how to distinguish between disciplinary misconduct and judicial error. How would you distinguish which judicial error deserves disciplinary action and which judicial error is just error which should not lead to such consequences? Based on which criteria would you determine whether it deserves or doesn't deserve disciplinary action?
Firstly, I would like to point out the following. Let's take, for example, a specific situation. For example, during consideration of a criminal case, a judge allocated time for a speech to the prosecutor and to the defense attorney. And for example, the prosecutor had half an hour for addressing the court, and the defense attorney was limited to 2 minutes. Like, you have 2 minutes and that's it, and finish your speech. And that's it, and finish your address. And that accordingly, there is no error. There is a direct intent of the judge with respect to the violation of the principle of adversariality between the parties.
Second question related to distinguishing between two important phenomena. Bangalore principles state quite clearly that not every ethics violation should be subject of disciplinary action. On what criteria would you decide which ethics violation should be punished in disciplinary process and which not?
The Bangalore principles clearly stipulate that if the violation of ethics of the judge is not an independent ground for the disciplinary proceeding. Violation of the judicial ethics is not a ground for disciplinary responsibility of the judge.
Are you saying that none of ethical violations can be sanctioned in disciplinary process?
No. Not like that with respect to ethical conduct of the judge. If I remember, something like that. That's what I'm recalling. That's one of the first indicators or something. And then it is stipulated that it cannot be an independent ground for...
Okay, so what else should be established in order for ethics violation to be punished in disciplinary action?
That it undermines the authority of justice. Of the independent judiciary.
From me, thank you.
Добрый день.
Добрий день.
Good afternoon.
I would like to follow up on my colleague, Commissioner Zlinczek's question regarding the difference between legal error and an ethical violation, and when a legal error could become an ethical violation. And you gave an example of a violation of due process. So the judge gave the prosecutor half an hour and limited the defense to 10 or 15 minutes. They did not have equal time in an adversarial system. Can you state whether there are any circumstances under which the judge would be subject to discipline if he or she misinterpreted or misapplied the law? So just got the law wrong. Is that ever grounds for disciplinary action?
It could be a ground for disciplinary responsibility.
Under what circumstances?
Навіть якщо, скажімо так, під час
Even if during this consideration of a case,
внаслідок помилки
even if because of an error, a judge violates key principles, it means that he refused to give right to a person to protect their rights,
порушив принцип рівності,
violated the principle of equality of the parties.
того ж самого принципу,
So it's the same, or violated the adversariality principle.
Sorry, violated, what was the last point?
Adversarial principle.
All right, thank you. In your motivation letter, you stated that your desire to hold the position of disciplinary inspector is based on a deep understanding of its role in the system of judicial accountability. How do you define, what do you mean by judicial accountability?
не зовсім зрозуміло.
Maybe I didn't get the context. What do you mean under it?
So in your motivation letter, you use the term that you have a deep understanding of the position of disciplinary inspector in the system of judicial accountability. And what I'm asking is, what do you mean in that sentence by judicial accountability? What does that mean to you?
Ну, від основних функцій дисциплінарного
So the key functions of a disciplinary inspector
початок формування
impact on the beginning of formation of a disciplinary case, which will be further considered by a disciplinary chamber of the High Council of Justice. And I have already mentioned it before.
це є основою, тобто
This is the foundation.
це є, має бути свідомість, розуміння,
So there should be understanding, awareness of an inspector that he or she should commit all actions in order to collect all possible evidences in order to form this case, because it will lead.
I'm sorry, I don't mean to interrupt, but I'm asking a specific question as to what you meant in your letter by, what does the term judicial accountability mean to you?
відповідальність.
So judicial accountability.
Ми розуміємо.
I don't get it.
It might be.
Yeah, I'm trying
Can we see what his, what is his original, it's in the motivation letter, what's the term he used? Right here.
Third paragraph.
This term, yeah, this is the term.
This is the term?
So can you say it out loud in Ukrainian?
So in the motivation letter, you have this judicial responsibility, if to be clear how it's interpreted. So very beginning, you have mentioned this judicial responsibility. Yes, yeah, that's how it was specified.
Ви ж там мали на увазі.
So maybe it was meant something different. No, you are referring to it in your motivation letter. So we would like to understand what you mean under this term as judicial responsibility said. So what's responsibility against, in front of whom, in front of what? So against whom or what? What do you mean there under this term of judicial responsibility? Maybe. No,
За дії вчинні,
what's the essence of it for you?
він буде
That's
відповідна відповідальність.
It's for the actions of a judge. There should be certain responsibility. So if a judge commits some disciplinary offenses,
Ну, у разі допущення вчинення
so if a judge commits such offense, I don't understand the context, so I can't recall it in my memory. Okay, I will quote it for you right now. In your motivation letter, you say, my position, my desire to hold the position of disciplinary inspector is based on a deep understanding of its role in the system of judicial responsibility and personal professional experience. So, Mr. Ehrlich has this question: what do you mean under this term, judicial responsibility? What's the content? How? Under which circumstances? So what did you mean when you wrote down in your motivation letter these words, judicial responsibility, that you understand this system of judicial responsibility? What is system of judicial responsibility for you?
намагаюсь пригадати.
I'm trying to recall the content of this letter. So what is the judge responsible for? The judge is responsible for, in this context, for
Порушення правил етики.
for committing some rules of violating some rules of ethical behavior. So there is a specific law. There are so many different preconditions for it, and it also includes Bangalore principles. So it's clear.
I'll just wrap up this line of questioning so I can move on. I know I've taken enough time here, but why is it important that judges be held accountable or responsible for their misconduct?
Ну, це очевидно це очевидно є відновлення довіри.
It's obvious because it will renew trust to justice. If a judge is brought to responsibility for commitment of any kind of misbehavior, it will avoid any arbitrary behavior in the judicial system.
Ну, візьмемо такий
So let's take
маленький мінімальний приклад, як
a simple, small example.
нещодавно в мережах медіа, да?
It was just recently covered in mass media when the HCC judge was brought to responsibility because he violated principles of access to justice. There was a disciplinary proceeding. So it means that it shall not be avoided unpunished because he denied a person with the right to justice, something like this. It was he denied the person right to protection.
Ну, в медіа я побачив.
Yeah, you know, I just read it in media, but I didn't dig into details.
One last question. You said at the prosecutor's office you conduct investigations from open sources. Investigations into what? What type of investigations?
Скажімо так, воєнних злочинів.
War crimes, so to say.
Thank you. Дякую.
Це було
It's it,
наші колеги.
so our colleagues, specialists from the United Kingdom, they trained us for the whole year. They trained us how to do it. They issued to us certificates on that matter, and some trainings were provided.
Thank you. I will maybe ask two questions just to give the floor to my colleagues. One of them is that you, in your motivation letter, when identifying the professional qualities that are important for this position, is in-depth knowledge of legislation, analytical thinking, and the ability to write well-reasoned draft decisions. And I do understand from your letter that you consider that you possess all those professional qualifications that are important for this position. Yes?
Ну, намагаюся.
No, I'm trying.
I understood. And what makes you feel or think that you have this? What kind of proofs? I don't know, feedback from your colleagues, or why do you think you have those qualities? That your decisions, draft decisions, are well reasoned, that you have a really very good analytical thinking and this kind of qualities. Could you please just describe, maybe you had some situations when you got a specified feedback and you understand that, well, people do think that you have those.
First of all, it's my personal belief that I have such qualities. Another thing, it's my professional experience for many years.
Unfortunately, sometimes just being in the position or working in the position does not necessarily mean that we are doing this in a very, very good way or perfect way, but probably you had some situations when you got this feedback. So I was asking about particular that your the judges that you worked with or colleagues were referring to you as a person having these qualities. That was my question. And a related question then would be about the personal qualities. You indicated that communicativeness and a desire for self-development and learning, those two indicated as important. Are there any others, or those are the main personal qualities that are important for this position?
Regarding the last question, not, of course, it's not an exhaustive list of qualities to get this position.
Thank you. Now the floor to Olga Popkova to ask some questions. Thank you.
Колеги, в мене невеличке питання. Олександр,
Dear colleagues, I have a small question. Alexander, tell me, please. How have you increased your qualification recently? And to your opinion, what knowledge are you missing to take a position of a disciplinary inspector? Because all of us, we know our weak spots. We are constantly learning. I'm speaking about myself, sorry. I can't say that I'm, a perfect specialist at all sectors, legal sectors, and I'm a judge in the commercial field. I'm not considering myself as a specialist in criminal field or administrative field. But for you, how do you assess yourself? What are your knowledge gaps, and when have you increased your professional qualification, and in what fields? As I'm a civil servant, each year we are obliged to increase our qualification. This year I have already passed a relevant program. Regarding my knowledge on disciplinary responsibility issues of judges, of course, as of now, it's a challenge for me. There are certain reflections on my knowledge in that field, but I can't say for sure that, having such long-term experience, I understand fully this field. So do I understand correctly that there are some gaps, but during the whole life, a human being is used to learn. Thank you for your reply. I have a small question to you, and I would like to dwell upon a very important your quality, as it's mentioned in your motivation letter, that you have experience of working during extreme workload, as you have been working at the Supreme Court and its very establishment, and the workload on each judge was so high. So tell me please more about your workload, because disciplinary inspectors face a heavy workload, and it's a constant workload, quite a high one. The number of disciplinary cases assigned to each disciplinary inspector, so it's high indeed. Disciplinary inspector should have some, some strengths and relevant qualities to handle it. Tell me about your workload. When the Supreme Court, the newly established Supreme Court started functioning, there was a huge number of unconsidered cases, and it means that it was a challenge. And this challenge was on the shoulders of new judges and the office of the newly established office. And these were not even hundreds, but thousands of cases. And the key task was to increase trust, to renew trust to the judiciary. That's why we tried to consider those cases not for the long period of time. And it also related to drafting of documents, working with huge volume of documents on. What was your working day? So how many hours did you work per day? At that beginning period, from down to down. So yeah, it was a huge period of time. So are you not afraid of facing such a huge number of disciplinary complaints? No, we understand such a volume. So do you think that you will handle it? The workload? No one promises that it will be easy, but I understand what you're talking about. And tell me, please, what's more important for you, quality or quantity? As a rule, as people say, when we have quantity, usually quality slightly decreases. But this is very important to combine the quality and the quantity to maintain a balance. Yes, to maintain a balance. That's why, of course, it's so important to have quality, but at the same time, we shall not forget about quantity. Thank you.
So now please. Now we'll come to the part where we'll be asking some questions regarding the financial or assets declaration, and the interview will come to the final stage.
Dear Alexandra, you were asked, as it's not a secret that this interview is being broadcasted, and we need to ask you these questions. So in your property declarations, you mentioned 2 land plots. Yes. So tell us more about those land plots. What are they? How have you owned them? And the first question. And second question, why in your property declarations from 2016 to 2021 you failed to indicate the value of those land plots? And how did you estimate this value in 2022 when you filled in your declaration?
Just for interpretation to be finished for colleagues. These are land plots obtained by me following the procedure of inheritance, largely speaking. But they were obtained based on the court decision, because when the will was prepared, that was happening inside the family ties. That was my grandfather's sister. And there was made a mistake. And the representative of the district administration corrected it. And then, during opening of this inheritance case, the notary denied because of this correction. So that's why I had to recognize my right for inheritance following the court proceeding. I'm not asking how, but you inherited these land plots, yes. The question is about the value. While from 2016 to 2023 you did not declare the value, and then you somehow determined it. How did you determine this value? If that was inherited, the value back then, as of the moment of accepting the inheritance, the registration of the right of ownership, all of these documents were there, and there was the expert from the State Geocadastre, and they were submitted to the notary's case. I did not have any copies left, anything. And where did you take this value from in 2022? You are declaring the value. During submission of the declaration, it connects from where? When you are filing the declaration, it uploads the value. It forms it value on its own and takes this information from the register. Very strange. With respect to Lexus car, manufactured in 2008. You acquired the right of ownership in 2021, right? Yes. You specify the value of 5,000 hryvnias. It was $200 back then. Was it the car, or what was the technical condition of the car? And did you invest in the restoration of the car? Back then, I did not invest any money in its repair because it was in a working technical condition. I provided respective confirmation. What was the purchase price? I provided the confirmation. It was $13,000. $13,000? Yes, back then. There is respective information. And why did you declare in your asset declaration that the value was not provided for 2021? In 2021, you bought this Lexus car. And in your asset declaration for 2021, you specified that the value was not applicable. Why? Because it was a technical matter. It was basically bought for one price, and there was some expert valuation, and it was uploading it, and accordingly there was a conflict in the declaration. If you bought a car for $13,000, you had to declare this figure. And tell me, please, did you have enough income at the position of the secretary of the court hearing to buy a car for $13,000? Yes, of course. Respective information was provided by me, especially that before the purchase of this car, I declared savings. Okay, next question. You are specifying that you are declaring that you are renting an apartment in Kyiv region from your mom. Yes. Is it free of charge? Yes, it's free of charge use. And what are the sources of origin of your mother to buy this apartment? Where does she work? Back then, she worked at an enterprise that was joint property of the married couple, that is together with my father. He was also working, and respective confirmation was provided about their income. Okay, and why didn't you declare the value in your declaration? Because that is property owned by another person, so to say, and these agreements were kept by her. Did your mom refuse you to tell about the price of the apartment? You didn't ask. I asked, but she didn't want to give this information. Using her rights, she believed that it was necessary to do that. And one last question. in this declaration for 2021, you declared your family members, and now you are saying that this is a different person. You declared your mom, father, and grandfather, and you did not declare any information about their property or income. Why? Well, and why did you declare them? Did you live together? Did you have shared household? No. Back then, I lived in Kiev, and they lived in Chernivtsi region. And why did you declare them as your family members? Why? You were not aware of the rules? No, no. Back then, I was submitting this declaration urgently, and somehow it was, what do you mean urgently? 2021. It was filed in 2022, and that was during the full-scale war, and when declarations were not filed at all. And they refused to provide you with this information, or why? First of all, why did you declare them as your family members even though you lived separately? And if you declare them as your family members, why didn't you declare their property and income? Well, because for their security reasons, they did not want to give that. They didn't want, but did you ask? Yes, of course. Okay, and my last question about your military duty. Tell me, please, when did you update your registration data last time? In May of last year, I think, when they obliged us to update data. In May of which year? 2023 or 2024? When the resolution about the need to update data was adopted, and once I did that, you specified that there were you have no grounds for deferment from conscription, and you have no deferment from mobilization. Yes. And how did it happen that you are not serving in the army and that you have not been mobilized or conscripted until May of this year? We were subject, all civil servants were subject to deferment in our structure. According to the resolution of the Cabinet of Ministers, they limited that to 50% of deferment from conscription. Were you included there? Yes, someone had to be not mobilized. And how did the management decide who was deferred and who was not? I do not know about the principle. Okay. Do you have Reserve Plus app? Yes, of course. Can you show it? It's been updated because I have poor internet connection here. Have you opened it? No, it's like opening because it's been uploaded. Just last week, when you asked this question, I updated Reserve Plus app, but I had to do that through DIA portal. So you have no problems with that right now? No, no, no. Okay, thank you. I have no more questions.
Thank you. No questions. Дякую, пане Олександр. Now you have a few minutes for your final remarks because our interview is coming to the end. So if you want to say comments or any remarks to the Commission, please do so. The floor is yours.
Thank you. First of all, thank you so much for the conduct of this competition. I am really happy to take part at this stage. And my key desire, not only mine, but probably of the entire Ukrainian people and of the world, is for the end of the war and for peace to come, for our service members to come back home, including the ones who are now in detention centers.
For your participation, your preparation for coming here, and of course we support your wishes, and we all are together до перемоги. Дякую вам.
Thank you.
Announce our decision on Wednesday, the 1st of October in the morning, so it will be broadcasted as well. You will see. Thank you and good luck.
Так, дякую.
Thank you.
Доброго дня всім.
Good afternoon to everyone.
Pani Svetlana, welcome to the interview for the position of the disciplinary inspector. Our candidate today is Svetlana Melnik. And first of all, I would like you to introduce to our commission, which is in its entire composition today. So I'm Reda Moliene, the chair of the commission, and also we have the commission members, Yulia Bokova, Olena Kovby, Olha Popikova, Pavel Zelinchik, and John Ehrlich. Would you have any requests regarding the composition or?
No, ні.
Thank you. So our interview will last about an hour. From our previous experiences today, we prolonged our interviews for 10 minutes or 15 because of interesting discussions, so it could be the case as well. I hope you do not mind to have a bit more than an hour. And we will give you a floor to present your motivation. Why are you applying for this position? What are your professional experiences that allow you to apply firmly for this position? And then we will ask some questions about your professional competences and also integrity. And at the end, you will have several minutes to say some final remarks. And the interview, as you probably know, has been broadcasted. If you have any information that falls under restrictions for its public disclosure, please let us know and we will take a decision regarding this. If you do not have any particular requests at this moment, so you could start from your presentation about your motivation and your main competences and experiences to be here. Thank you.
Greetings again. Good evening. No, I don't have any requests or motions. Thank you so much. All is clear. I have quite a long professional path. My professional path has started from the position of a lawyer in private commercial organizations. My key tasks were to ensure lawful commercial activities, so to control that indeed those persons fulfilled their duties and carried out their activities according to legislation. Then, for more than 20 years, I had worked in academic and pedagogical field in the higher educational facilities. I taught law. Mainly, it was commercial business, entrepreneur law, and I also focused on competitive law, specifically competitive law of the European Union, foreign countries, and of course national, so of Ukraine. I have passed this path and it was quite a long time. As I have mentioned, it was more than 20 years. I worked at different positions and roles in the academic field. I was a lecturer, professor, an associate professor, a head of the department. I have more than 100 academic works. I have an academic degree and an academic title. I have taught not only the law fields which I mentioned, but I also taught some innovative courses for master students, for postgraduate students, specifically dedicated to law interpretation and law enforcement. And I also taught commercial law for future judges in commercial courts. Afterwards, it happened, and it was quite a hard decision for me. But it was related to some family reasons. I needed to move to another role, to another work. And for a little bit more than a year, I led the HR service of the National Medical University, and it was a quite hard time for that university when I was performing my role there. So this was a period when a new rector was being selected, and it was a hard process, which was complemented with constant litigations. So de facto at that moment, the legal service was under establishment, and I helped them with some legal issues. And in particular, I helped them with development of some local normative acts, for example, rules or procedure on competition for some employees for this educational facility. Now, afterwards, it's already the fourth year as I lead the Department of Analytical Work, Generalization of Judicial Practice and Judicial Statistics of the Odessa Court of Appeal. And maybe it's not a hobby, it's already a tradition. All the time, I'm in the process of learning. I calculated certificates which I have gained for the last 3 years as I have been working at this role, and there are 18 certificates. All of them, or most of them, were received through remote learning in extra hours, so beyond working hours. It was my independent learning activities together with the National School of Judges, for example, or I learned virtual currencies from the London City facility from the criminal perspective. Or the last course which I have had, it was a course on the Council of Europe regarding cyber crimes and electronic evidences. So what I'm meaning here is that I'm just used to learn all the time. Regarding my motivation, so of course I realized what the High Council of Justice is, what its path, what the authority was before there in Ukraine, dealing with the same things. I have even digged into the history. So I read the first competitions regarding disciplinary inspectors, what were the requirements for the first competition, and realized that I don't meet requirements, as I'm not a lawyer, I don't have a bar license, I don't have judicial experience. That's why at that moment I put this thing aside, and I participated in a competition for appellate courts, but I didn't succeed. And I didn't pass the cognitive test there. Actually, I didn't. I just confused some timing and didn't have enough time to open all the test questions. But then, when I read a new announcement for the position of disciplinary inspector, now I read through all requirements. I understood that legislation has changed, and I could apply for this position. What's else important? At my position, I have also prepared draft proposals for the annual reports to the High Council of Justice regarding independence of judges. And at that moment, I was so interested in such questions. So, for example, we are used to say that in legal democratic state, as a rule, there are 3 branches of power which are equal, independent, and we have also the checks and balances system, and they, in agreement with each other. But, for example, Article 93 of the Constitution doesn't provide judiciary with the legislative initiative. Yeah, there are obligatory findings, conclusions regarding the, the judiciary system, regarding the judiciary in general, how to become a judge, and so on. But the judiciary system doesn't have this right for judiciary initiative, for legislative initiative, and it's also being insisted upon by the High Council of Justice. And I think that improvement of the system of a disciplinary proceeding regarding possible violations by judges is the most important, or one of important aspects regarding giving judiciary branch of equality together with other branches of power, because we know that legislative branch could be dissolved, members of parliament could lose their mandates and so on. We know that you can, announce distrust to the government and it will be dissolved, and it's all formulated in laws. But procedural issues, procedural aspects, with the purpose of strengthening its functions, with the purpose of providing professional competences to disciplinary inspectors. So what I mean here, to establish a system which ensures protection and, so quasi prosecution, it allows to build such a system which will strengthen, which will strengthen the judiciary in general, which will make it independent and at the same time accountable. So I think that my experience, my skills could be useful, and I would like to be useful. Thank you.
Thank you very much, and for your presentation and your presentation of your professional experience. And regarding this experience, it's really interesting that you have more than 20 years, as I calculated, of the experience as an academic field, so to say, and as a professor and researcher. And after that, you turn to some more practical work, so to say. So, and now you were in Odessa Court of Appeal, working for 3 years. So, what was the main inspiration or the condition that made you to turn from this academic field, which took a considerable part of your professional life, to a practical field of law?
So here we have two main reasons. First of all, the first reason is absolutely family related. So it happened that the clinic of this university helped a lot my husband during a very difficult period of time. Just to remind you, it was COVID times, and there were some limitations with medical treatment, and he had some urgent situation, and they helped a lot. And it happened that I communicated with people from this environment, and I even didn't know what positions they hold. And these people hold quite high, important positions of this medical university, and they invited me to take this vacant position and help them. Before it, they had consulted with me, but it was like, random phone call and asking for advice, asking to help with something like this. And I also would like to say that since 2016, I have submitted my application to participate in the competition to the Supreme Court, to the Commercial Court of Cassation. But at that moment, the law provisions envisaged that the academic degree was considered a relevant one if it's defended in the higher education facilities. And I defended my thesis in the facility which was led by Mamontov, Valentin Karlovich, and that facility was in Donetsk, and my academic degree was not considered as the one as acceptable. But then legislation was changed, and I was accepted, but the rules were changed and so on. So what I'm trying to tell you is that I tried to join the practical field for quite a long time. It was like 10 years ago.
It's very clear, your explanations, and indeed sometimes some coincidences in our life make a big difference and big impact on our career, and let's hope it's for positively. And you indicated that you were trying to apply for the position of a judge. And now, after you have this how to say, your academic achievements, they are evaluated as enough for being a judge. So you would go for this position because now you would have to make a choice between being a disciplinary inspector and or a judge, which is a bit different position. So what would be your preference?
No. I'm not going to, and I have not applied for this position. And I was asked actually why I'm not applying right now in the competition for the judges of first instance. And yeah, I was applying for criminal specialization because there were almost no vacant positions in commercial sector. But I'm not going to. So I'm not applying right now. I'm not participating right now in those competitions. I'm not going to.
I wanted to ask you about your interest, in particular interest in the system of judicial ethics and the work of the HCJ. But as you indicated already that you were studying those reports on judicial independence, and you had some suggestions and propositions regarding it, and also you indicated an interesting observation about the role of the judiciary as an independent power related to the accountability and moreover to this disciplinary liability of judges. So my question would be, do you consider accountability more or less the same or a similar concept as judicial liability for violations?
No, I'm not really getting what accountability you are talking about.
That this concept of judicial independence goes together with judicial accountability, independence and accountability. So this concept of accountability, is it the same or similar as the concept of disciplinary liability of judges, or it is something more? What is your understanding and opinion about this concept of accountability?
In my motivation letter, I specified that I believe that improvement of issues of disciplinary liability strengthens. On the contrary, judges do not lose anything. It strengthens the judiciary. It makes it more worthy. More equal with other branches of power. And I think that it gives a higher status and more trust for this of the society in the judiciary.
So, and also in your motivation letter, I noticed professional qualities and ability and desire to learn, to study, and as you already mentioned, you are a very curious person. You are trying to develop yourself, and you are keep doing this. But also as personal qualities, you indicated this balance, and I'm curious what you perceive as balance, which is important according to you. It's important for this position.
Balance from the perspective of training and experience, or
for me it's interesting. I don't know, maybe it's interpretation, but in your motivation letter is indicated that the following qualities will help me become the best candidate, and then it's listed: and personal and analytical mindset, balance, then diligence and ethical behavior. But balance was indicated as one of those qualities. So I'm curious, what is about balance?
from your motivation letter, if Madam Rada allows, I will try to remind it to you again. The following qualities will help me become the best candidate. Personal qualities: analytical mindset, balance, diligence, ethical behavior, desire for personal growth. This balance, what do you mean by it?
How do you understand and
Тобто я
How to say, I'm not rushing. I'm very reasonable. I will study everything that I can study. I will study all the materials, everything. Sometimes even I'm trying not to look, if we are talking about some academic achievements, in order to form my own understanding, I'm studying the issue in depth. I'm going in depth into this issue. I try to study everything that I can study. And I abstract myself from considerations or reflections of other people so that I would be able to form my own opinion, then analyze other opinions, then I agree or disagree, then I explain why, and I understand that all of that is subjective because we are all individuals and still we have some subjective thinking, but still I try to take the decision that will be as objective as possible in order to come to the solution to some problem or some idea.
well understood now. Thank you. Also, I will ask one more question, and I will give a floor to my colleagues, though I would love to discuss further. But as you are, I would say, kind of a newcomer in the judicial system, and you have a huge experience and a huge perspective. So usually newcomers, they observe those challenges or shortcomings of the system better than those who are already here for 20 years. So we are getting used to everything that is around and we do not notice. And those who are coming to the system and work for a while, like 3 years, so what would be the most, important or challenging shortcomings, internal shortcomings of the system? I'm not talking about the lack of the respect to judiciary or those elements that are more external, but internally, what are the main problems that should be solved immediately in order to have stronger judiciary?
I will not be original, and I will say that nowadays the urgent problem is the problem with the lack of judges. I do not understand how it is possible to work in this speed, under this workload, to take decisions. I'm looking at judges of our court, and that is some work leading to exhaustion, and that's like the first item that I would put. We need human resources, competent human resources that will come and start working at once. Talking about the apparatus of the court where I work, we have to try to create conditions that will be as comfortable as possible for judges so that they could perform their duties and be as close to visitors of the court as possible. I mean, to people who are coming with their problems to the court. That's why, from this perspective, that's about transfer to the digital system for the court functioning. It is really important because it speeds up many processes and makes them more convenient. That's unfortunately sometimes about the lack of resources in the apparatus of the court as well, because everyone is discussing that, and for a long time, including the High Council of Justice, we have very low salary for employees of the court apparatus, and we have a very high turnover of human resources. Probably that's key.
If the problem or an issue with a workload and the lack of judges and the financial and technical support of courts would be solved, so you think that the trust in courts would be much higher or even be the highest ever, or still there are some other issues that make sometimes public and society not trust the court?
Probably. I'm not mistaken, but I can say that mostly people of quite mature age are coming to courts, and probably they live through traditions. There is a tradition of distrust in the court, and it will remain, and we cannot escape this. That's obvious. But you see, if judges have lower workloads, they will take decisions, they will have the opportunity to take decisions. Because right now, with this workload, by the way, I'm sending responses to the request of disciplinary inspectors about the KPIs and the workload of judges in our court as compared to other courts. And of course, they send these requests to us. So there will be distrust. We cannot have absolute trust. Maybe these are also some other factors, including some corruption elements. They exist everywhere. If we are honest, somewhere they are more prominent, somewhere they are less prominent, but somehow like that.
I would like to give a floor to Yulia Bokova to continue. Thank you.
Дякую.
Thank you. Good afternoon, Svetlana. I have many questions, but limited time. Very interesting interview. Tell me, please. You've mentioned that you engaged in the commercial sphere of law. Why did you choose? And why are you the candidate for the position of the disciplinary inspector? Because this is a completely different sphere. I believe that, after all, these are different positions if we're talking about the judge and the disciplinary inspector, firstly. And when I was applying for the position of the judge, I was applying to the criminal specialization of the Court of Appeal. And when I was applying for the position of the judge of the Supreme Court, I was applying as a candidate to the Cassation Commercial Court, you know? So I have this diverse experience. Do I understand it correctly? In one of your answers to the questions of my colleagues, you've said that thanks to responsibility, the disciplinary responsibility of judges, the judiciary will become stronger. Can you justify why? No, why disciplinary responsibility is making the judiciary stronger? Or maybe there are some other factors as well. Of course, there are other factors. And what are the factors determining the completeness and independence of the judiciary? There are many other factors, that is the method of appointment of judges and their duties, and the possibility to bring them to disciplinary responsibility. Disciplinary responsibility is not the only factor, of course, no. But disciplinary responsibility, in my opinion, makes the judiciary more balanced, more comprehensive, because we see not only rights and duties, but we also see consequences of improper fulfillment or failure to fulfill duties. That is the structure that becomes complete thanks to the existence of disciplinary responsibility, among other things. So, do I understand it correctly that the more judges are brought to disciplinary responsibility, the stronger the judiciary becomes? No. I'm not talking about numbers. I'm talking about the institution itself. Now, by the way, I've seen figures, very illustrative. From 1 to 3% of disciplinary proceedings reach the stage of judge being brought to disciplinary responsibility from among all submitted complaints. So I'm not talking about figures, I'm talking about the institution itself, and it has to exist. And then the society will trust judges more. You know, that is the absence of impunity. That is, yes, that this impunity is not there. Now I'm not talking about the number of judges brought to responsibility. Thank you. If I've made sense. Thank you. Tell me, please, is always committal of the misconduct by a judge leading to the disciplinary responsibility? If we are talking about disciplinary offense, yes. But if we are, which misconduct in life, which one? No. If there are facts showing that a judge has committed some disciplinary offense, for example, delay of the case consideration, should the judge always be brought to disciplinary responsibility by the disciplinary chamber? No. What are the factors influencing that? A range of factors influences that. For example, workload of the judge, workload as compared to the average workload in the court. If it exceeds, then this is the objective reason and not some intentional attitude of the judge towards this case. That's about the personal characteristics of the judge. That's about the absence of disciplinary sanctions applied to the judge previously. That's about the range of factors that have to be evaluated always. What is the term for bringing a judge to disciplinary responsibility? Disciplinary complaint is considered as a rule preliminarily within 30 days, then 30 more days are given, and if I'm not mistaken, it depends, 3 years, if I'm not mistaken, 3 years, yes. Thank you, I have no more questions. I will pass the floor to Madam Olga in this block, and I will ask the final question. I'm with you. Svetlana, I would like to talk with you on the following topic. Until now, there is still ongoing discussion in the judicial community among lawyers about the fact that openness and transparency of the disciplinary proceeding with respect to a judge may inflict harm on the authority of justice. What is your opinion about this? What do you believe regarding that? I believe that yes and no. There is no clear answer to that, because openness for the society is about trust, but at the same time, sometimes some indecent things, for example, about the personal life of the judge, may really cause distrust as well. So that's why I do not have some final answer. I'm hesitating to answer this question, either yes or no, both yes and no, depending on circumstances, probably. Okay, thank you. That's really a very controversial issue. Then let's continue with controversial topics. Do you agree or no with the fact that sometimes the goal of the disciplinary proceeding is not to bring a judge to disciplinary responsibility, but rather to somehow, if I can say that, some preventive function? If you agree, then please justify your response. If no, please also provide your arguments. Of course, I believe that it's also about preventive function. That's, by the way, also an axioma that any legal responsibility is about prevention, first of all. Prevention of offenses in the future. Prevention for this particular judge and for other judges who see what might happen, even it may reach the stage of the dismissal of a judge for some gross violation. So I believe yes. In your opinion, we've asked this question to the previous composition, and I am interested in hearing your opinion. In your opinion, what is the prerequisite for the establishment of the service of disciplinary inspectors? Because you know, that is a quite complicated, long procedure with the conduct of competitions, with the use of quite serious selection process. Because the High Council of Justice was considering complaints, sometimes believed that it was quite successful in considering the complaints, but at the same time, the legislator and the service has been established. What do you think were the prerequisites for the establishment of this service? Maybe to have this balance in the quasi-judicial process with respect to judges, in order to have it separate, to separate the prosecution function from the defense function, so to say. Secondly, we've taken this international commitment to implement this reform, and we also have to fulfill that because we've taken this commitment. Thank you. If you allow, colleagues, I would like to ask one final question from me. Now it's about functions. What are legal consequences of withdrawing the disciplinary complaint? Do you mean withdrawal at the stage of preparation, right? If the disciplinary complaint is withdrawn, then the disciplinary case is not considered. Okay, understood. Thank you.
Добрый день.
Good afternoon. Good afternoon.
You referred to sort of, I think, a generationally influenced historical distrust of the courts and the judicial system. You said that people of a certain age don't trust courts or don't. Where do you think that comes from, and what can be done to overcome that distrust?
Thank you for your question. So maybe that the judiciary system was so closed, especially earlier, and it caused such a distrust to the judiciary. Now processes are transparent. It was unclear how judges are being appointed, what they do there, how they justify their decisions, what's their motivation. Everything was unclear because, again, it was the process was closed, but now the process is open nowadays, and I think it only helps the judiciary system in general, because such openness leads to the trust to the judiciary. And maybe there were some other factors, but I think that, yeah, this is a key one.
And does that openness you just referred to, in your opinion, relate also to the service of disciplinary inspectors? Does it carry over to the service?
It's hard for me to say. I do not perform these functions, but what I can see is that yes, indeed, I even can say that even on the stage of competition, it's already, this procedure is so open. I have never seen such open competition. Everything is published, everything is broadcasted, everything is publicly available. So I think that yes. But of course, there are some things which cannot be disclosed, some personal things, confidential things, the judges, persons, and so on. You cannot share this information, but the general procedure, documents, their publication on the official websites, decisions of the disciplinary chambers, broadcasting, everything, everything speaks about the openness.
Can you tell me how familiar you think you are with judicial ethics?
The Code of Ethics, Judicial Ethics, I have read it. I even contributed to the proposal regarding the last version of this code. So I've prepared some proposals, and it was in the version of the draft proposal on behalf of the court. Then they were reviewed by judges. I have also read through the Bangalore principles and relevant comments to it. So the literature which was suggested to prepare myself to this competition, yeah, I processed it and I read through it. Whether I know it perfectly, maybe not. I'm not a judge. And from such external perspectives, and yeah, maybe I understand some things. Thank you.
And what role were you in when you were making comments or proposals for revisions to the Code of Judicial Conduct?
I was the head of the Department of Analytical Work, Generalization of Case Law and Judicial Statistics of the Court of Appeal.
My last question is, my last question is, what experience do you have in conducting investigations?
I have no such experience. I have never carried out any investigations.
Dziękuję.
Good afternoon. For us, it is always interesting to read the whole titles you have in Ukraine, so I will repeat it. Head of the Department of Analytical Work, Generalization of Judicial Practice and Judicial Statistics. From your work within this position, what do you think may help you in this new position? Was there any information process, knowledge which you acquired and can be beneficial in the disciplinary inspector's role?
Thank you for a question. What could be useful at this role? First of all, that's a role in the judiciary system. That's the Court of Appeal. That's the first thing. So I know how work is arranged in courts. I understand how a judge works because I also participated in the competition for the position of a judge, and I studied this issue. I watched how it works actually in courts. So generalization of judicial practice, that's about a capacity to analyze, to group, to describe, to apply it. And statistic-wise, it's clear. So it's about taking all these processes and transferring it into figures for better understanding and for easier usage. So I think that analytical mindset will be useful, and it will be also useful in the procedure of investigations. This capacity to take the most important thing, to differentiate from the most important things and less important things. I think that understanding of such processes will be very useful for me.
A follow-up question. Did you do within the generalization of judicial practices, did you also generalize anything related to disciplinary cases or not?
No, I didn't have such experience. I only provided information regarding the workload. So on requests of discipline inspectors. So yes, I interact with them.
Thank you. So now my technical question. We already had some interviews today. Did you have a chance to listen or watch the interviews we conducted with your colleagues or not?
I didn't do it intentionally in order to have my personal opinion, my own opinion.
Thank you. So I would start this part with this question. In your words, not citing a legislation, but in your understanding, what do you see as the essential role of the judge is in society? What is the substantive role of a judge? Substance of the role of a judge.
To achieve justice, maybe, because justice is far beyond achievement. It's difficult to achieve justice, and it's hard to achieve it. But maybe justice, yeah, you know, in any case of any specialization.
Thank you. If we now take the modern Ukrainian history, let's say since 2010, do you think there were stages when judges betrayed their role? Or which cases or events do you see as the most significant deviations from the ideals you just mentioned? Achieve justice. In the last 15 years in Ukraine, were there cases where judges deviated from this ideal? Which are the most serious in your view?
You know, you're asking more about negative things, yeah? Those things which undermined, those cases which undermine such thing. Maybe the latest notorious case, that's the case of the former president of the Supreme Court. It's so well known in the society, and you know, and the state of affairs and how it goes, maybe it's known, it's publicly available to everyone. So the corruption element is so negative, is so painful, not only to the judiciary, unfortunately, or maybe not unfortunately, I don't know how to say it correctly, but yeah, indeed. So this is, these are so upsetting things for everyone, actually.
And how, in your view, did Ukraine deal with these occasions? Were all those who should have been held accountable, in fact, held accountable? Or were there cases when some people faced responsibility and others didn't?
I think that there were such cases, and information about those cases was also published in mass media, in professional mass media, and it's also about dissolution of a court in Kiev. There were such cases when people were brought to responsibility and where people were not brought to responsibility. I don't want to give some names now, but yes.
And in general, how would you evaluate Ukraine's ability to deal with strong evidence of manipulations in the judiciary, not only by judges, but also by other figures who participated, for example, in judicial selection processes? How do you think Ukraine deals with those strong evidences? Has the system been resilient enough to respond, or has the accountability not been as effective as it should? What do you think?
I don't want to say that we are constantly in the process, but I believe in Ukraine. I believe that all will be good, that we will manage. We are quite smart, we're smart enough. We try to go forward. Right now, we are in this so difficult period of time. We are amidst the war. You know, when I was coming here to this location, I was looking through the draft law, which has been suggested since the March of this year regarding to strengthen disciplinary responsibility of judges, some rulings, and some other issues. And in the explanatory note to this draft law, it was stated some proposals, and there are some already proposals regarding making amendments to the law, saying that abusal of complaints shall be stopped. I have already mentioned figures, and the situation is so drastic, so terrible. It's about costs. It's about costs of financial costs, human resources costs, timing costs, and so on, to check, to verify, so on. And for example, the example was given of the United States of America, where for submission of further complaints, it's suggested to define a fee. So if there are cases of abuse of a right to submit a complaint, or there are cases of pressuring a judge by the same person, so it's suggested to define a fee for each next complaint. But, for example, it was said that a right to submit any complaints at all within several years could be limited by certain complainants. So, this was like an example. So we are fighting in different fields, but I think we will win. Everything will be good. We will manage to do it. Microphone, mic.
My last part will start with a question. I would like to introduce it with description of a failure of a judge or public official. It can be caused either by temptation. Somebody is offered a bribe or a nice house or political power, or threat. If you do not do this, then you will face consequences and your career is over. Even if it is illegal, you better do it because otherwise you will be done. So temptation or threat, it can happen in real life. How would you react if any of these happened to you in the new position of disciplinary inspector? Because it's a serious position. You can make somebody's life miserable if you start the disciplinary case, or you will close your eyes and do not see something serious. It very much depends on the ability of the person to sustain such pressure and face the situation. How would you react if temptation or threat comes into your Tuesday afternoon, someday in future?
Do you mean that regarding consideration of a disciplinary case regarding a judge, for me not to do it, yes?
What would you do if the influence is coming? If somebody approaches you, you shouldn't do this, or you should go after that guy even if it is not that serious, but you better get rid of him because we don't like him.
Yeah, it's hard to do, because first of all, I'm not of that age, I'm sorry, but I have quite enough experience, and I can resist this pressure, even despite of my gender. Even despite of my gender, I think that I will manage to handle it. I don't think, that it's possible to pressure me like this.
Okay. Have you ever in the past faced a similar situation when somebody tried to directly or indirectly? It doesn't need to be threat. It's just expectation, and you understand what is expected. Have you been in such situation? Can you provide some details? Of course, not names, but what was it about?
Yeah, there were such situations. So first I said no, But then I even didn't try to say no. I just realized that I just knew that it's in vain. I don't need to do it at all. And they just even didn't reach out to me with such proposals.
In general terms, describe what was the pressure about?
So it was related to my lecturing activities, of course, for me to help a student or postgraduate student with their work or with their thesis, to close my eyes on something. It was impossible. You know, generally speaking, I told my students that you need to do it as much qualitative as possible. It's not interesting for you now, but yeah, I'm not mentioning internal dignity. It should be the first thing, the key thing. But even if it's not interesting for you now, but anyway, you realize that there are so many different competitions for different positions in Ukraine, and all your drawbacks could become obvious in some time in future. That's what I told my students. And when anyone reached out to me with some proposals, I always said no. And afterwards, they were even afraid to reaching out to me with such proposals.
Thank you. So now we would like to proceed with the part of integrity and property and assets declaration. So during the preparation for our last stage, we asked some questions the candidates about their declarations of assets and related issues. So we got your responses regarding your property declaration, and it's the one apartment in Odessa, total area of 47 square meters, and also garage, no other property. It's owned by you, your husband and son. No particular issues further arose, and also there were some questions regarding your cars. First of all, the declaration, because one of the car was not re-registered and declared as the property of your husband, and you indicated that it was a mistake. You made an amendment to the declaration. Also regarding the sources of income for acquisition of those cars, you precisely indicated that it was family savings and credits, and you explained everything. So from this perspective, there are no further questions. I would like to refer to one of the things related to your academic activities. There is an article published in 2019 together with co-authors, and the article is Legislative and Institutional Characteristics of the Competitive Component of Economic Activity in Ukraine. So, and this article, as far as we got the information from open sources, that it was published in Russian. And usually the articles, they are published either in state language if it's published here, or in some other foreign languages if it's published in some international magazines, etc. So what were the reasons for publishing this particular article in Russian? What is the context of this? Could you please tell?
Thank you for your question. I will explain. Probably that was abstract from the conference and not the article. And if that was the conference, then probably the working language was Russian among other languages. And if the working language was Russian, and if this speech was presented in Russian, then the abstract was also published in Russian. I'm fluent in Russian. That's why it was not an obstacle for participation in this conference, probably. So I was complying with all the requirements set out by organizers of this conference. I have many articles. If we search, I have articles in Russian, in Ukrainian, in English, many articles.
Thank you. And there are particular questions regarding the trips to abroad, and I would like to give the floor to Olena. Member of the Commission, Olena.
Якщо
also you will ask.
можливо, я
If possible, with respect to the previous question of Reda about your article, but you broke the law. Because the law on academic and technical activities in the sphere of academic activities, Ukrainian is the state language. So all your publications were supposed to be in Ukrainian. I'm sorry. You know, if organizers of the conference allowed, as a rule, the invitation for participation in the conference specifies the working language of the conference. So they would not have accepted the abstract if it somehow broke the rule. I just do not remember the particular date since when this provision has been enforced, but that's the first time I'm hearing that I broke something from the perspective of language in the article. It's 2019. Since 2014, we have ongoing war in Ukraine. The enemy is Russia, and you thought that it was possible to take part in the conference as the academic in the academic conference using the enemy's language. In this context, I did not consider it even. You did not think about that. No, I did not think about that at all. But probably in 2019, you should have thought about that. Of course, you know, I used to study in the Soviet Union on the territory of Siberia, and I have many classmates from that territory. I have not kept in touch with anyone. Moreover, I ended all relationships, especially after 2014. Okay. And then my family member is defending the country for 3 years now. Yes, I read, and my huge gratitude and respect to him for that. You were asked a question about trips to the occupied territories of Russia and Belarus. You stated that you and your family's members did not make such trips. But according to information that was provided to us in response to our request, after March of 2014, during the period from 2018 to 2020, you visited the territory of Russia 6 times. Can you please explain that? That's just some coincidence. That was not me, for sure. I swear that I did not visit. Maybe that was full coincidence regarding the name and surname and patronymics. I did not visit Russia and occupied territories. The last time when I was on a business trip, that was in February of 2014, in the center of Legal Academy in Simferopol. That was my last trip. The matter is that here in this response we have the passport number. In order to refute that, you have DIA, right? And your foreign passport there, yes. Let's just check. We will check that, but I did not go there. I have no marks in my passport. That was not me for sure, and I'm very surprised that this information exists and that my passport was mentioned there. I did not visit it. I do not even know. Can you now open DIA and name the number of your foreign passport? Yes, I can. But if that coincides, that's still a mistake. 1 second. I'm very surprised, honestly. May I come up to you? You can announce it. Maybe that's personal data, not for public broadcast. We can switch off the broadcast.
Our broadcasting for this because it's personal data. Please this clarification of personal data. So, dear Commission members, do we have any other questions? Yes, please.
I want to clear up some confusion in my own mind with regard to the article that was referenced earlier. You referred to an abstract, and that the abstract is what is presented to the presenters as to what you're going to talk about. And my understanding is you said the abstract was in Russian. Was the article in Russian or just the abstract in Russian?
There was no article at all. There were only abstract of the conference.
Abstract, okay.
Я перепрошую.
I'm sorry. These abstracts were published by the organizers of this conference, right? They provided and published abstracts of your speeches. Yes. So it was not your publication. No. We are submitting our abstracts. There is no automatic recording of abstract. No, we are providing abstracts for the organizers. The organizer of this event thought that it was possible to publish that in Russian.
Other questions? Okay. So our interview is coming to the end. So now there is an opportunity for you to say some final remarks, please.
Thank you so much for your attention, for the time dedicated to me, for the opportunity to speak in front of you. You have a very uneasy mission. I'm also very worried because it has been a very difficult competition, and I'm happy that it has been so open, that I've had an opportunity to talk to you and to somehow to try to convince you that I maybe would be able to perform these functions. I would like to wish all of you the best and patience and safety and peace as well. Thank you.
So we will announce the results of the competition on Wednesday, the 1st of October in the morning, so you will have an opportunity to watch online the results. So thank you very much for your participation, preparation, and being here, and good luck to you. Thank you.
Goodbye.